For judgment, item number 1, WPC 33278 of 2022, 2020 and batch of banks.
This court does not find any merit in the nature of challenge made in the petitions and declines to read down Rule 89(4) of the Central Goods and Services Tax Rules 2017 and Odisha Goods and Services Tax Rules 2017. The writ petitions therefore stand dismissed, but in the circumstances with no order as to costs.
Supplemental list. Fresh submission item number 2.
None of this dismissed.
Item number 3.
May I please, Your Lordship? I'll be permitted to
Withdraw.
appeal for union will you?
All right.
Will I-
Dismiss this withdraw. All right.
Item number 4.
It might have been impromptu, Your Lordship, because
Hmm.
second appeal stay revision.
Right. None of this dismissed. All right.
Milots. GST in the Milots, no
Same.
tribunal. And here Milots have paid the entire tax, interest and penalty Milots
OS.
before the first appeal notes.
All
So
right.
your lordship may only kindly admit it.
Right. Notice, yes, notice. Then you say, Mr. Curry informs the court that the entire demanded tax liability has been paid.
Penalty is also paid.
Penalty, interest penalty, your lordship would get it at page 47 in the first appeal order Milots.
So
Yes,
simply
that is-
say list on 8 March, is it?
Excess has been paid.
Not 8.
Excess has been paid.
My lord.
This order is on 8 March. So it will be the immediate next 9th March. I'm at order. Nine. Nine.
Much obliged.
Item number 6,
9th March, that's what.
item number 6,
None appears. The appellant dismissed for non-prosecution.
item number 7,
None appears for that.
Item number 7, the account has been settled.
Yeah, counsel of the appellant states that the appellee has been rendered infructuous on account of subsequent developments. It is disposed of as such.
Okay.
item number 8,
None appears for the appellant dismissed.
item number 9,
I have challenged the order of honorable single judge on the ground it is a nullity, my lord. The matter was sent to the honorable single judge. At the time of taking up the matter, I submitted that the matter has not been assigned to that bench. Knowing that the honorable single judge has directed it to you go and file a PIL. It is not a PIL, it is my personal interest matter.
I see. Alright. The appeal is directed against an order dated 11 November 2020 passed by the learned single judge, dismissing the appellant's writ petition civil 17799 of 2020. Paragraph. A perusal of the impugned order reveals that the learned single judge, on the basis that the petition was in the writ petition in the nature of a public interest litigation. Full stop. A perusal of the writ petition reveals that this is, in fact, not in the nature of a PIL at all. Full stop. It is a challenge to an order passed in an election petition.
No, my lord.
No.
I have my residential house. In front of my residential house, the government land is there, my lord. I am using that as my right of way, my lord. Another person is constructing the house in the government land, stating that it is a government land. Therefore, I approach the Tahsildar as well as the collector.
Right.
That-
All right. So you see the the prayer in the writ petition was for a direction to opposite party number 4. For a direction to the
Initiate
Tahsildar Rajnagar to initiate proceedings against opposite party number 5 under the Orissa Prevention of Land Encroachment Act, 1972. Full stop. Consequently, there was no element of a PIL at all in the said writ petition paragraph. The impugned order of the learned single is accordingly set aside, and writ petition civil 17799 of 2020 is restored to the file of the roster bench of the learned single judge, where it will be listed for directions on 6th February 2023.
Pardon me, my lord. Item number 8, we do apology, my lord. It became infructuous.
Which one?
Item 8.
1 minute, sir. It will be called out. Just wait. We are just disposing of this matter.
The Honorable Allahabad High Court decided, taking the decisions to Honorable Supreme Court, that it is a nullity in the apply if the matter has not been assigned to that bench.
Done by
The Honorable Chief Justice.
I see. All right. Okay.
my lord. Next is item 10, item 8.
8 of just in practice. All right.
Item number
Your
10,
Lordship, I'm sorry, Your Lordship, within a week, Your Lordship, a week time will be granted to file the substitution application.
No, it's a 2014 matter.
Lordship, the opposite party, Your Lordship, the name of opposite party has already been changed, Your Lordship. Your Lordship, within a week, Your Lordship.
No. Already more than a month is over, sir.
Your Lordship, within a week, last chance, Your Lordship. Your Lordship, then
It is trade discount matter. It is already covered. Trade discount matter.
Your Lordship.
Then
Only
Yet
opposite,
limited and other cases
Your
are
Lordship.
already we have decided.
Your Lordship.
so why
Since the name has been changed, only substitute.
it's all right.
Your Lordship.
You see the issue raised. The issue sought to be raised in the present petition. About entitlement of the dealer to claim deduction towards quantity discount has already been considered by this court in SEAT.
CAT limited, Madhuri out.
So, by launch, I may be pumped.
Consequently, no substantial question of law arises for this court to consider the present revision petition, which is accordingly disposed of. Right.
Obliged.
Item number 11.
The defect will be removed in the course and same order may kindly be passed.
The case has already been admitted.
My lords, I am appearing for the respondent 11 to 15, my lords, item.
All right. Same order.
11, 12, 13, 14, 15.
Yeah, 11 to 15. Right. All right. Deeply.
Item number 16.
None appears for the appellant dismissed. Non-constitutional.
Item number 17.
Same order.
Item number 18.
Please, my lord. Lord, the substantial law suggested at page 14, my lord, whether in the past and subsequent case, the tribunal was right in law in holding that the purchase in cash amounting to rupees such were to be disallowed under the section 40A(3) of that when the tax is on the real income and not on the purchases. Whether the second question, my lord, whether income tax appellate tribunal was right in holding that in case of a genuine transaction also hit the section 40A(3) of the Income Tax Act and are not 6DD of the Income Tax Rule or the circular issued by the Central Board of Direct Taxes, supply number such and such. Whether in the fashion of circumstance case, if the transaction is done for the first time under honest belief with bona fide reasons, can also be denied without giving warning in case no loss had accrued to the revenue. And the fourth question, my lord, whether in the fashion of circumstance case.
All right. You say notice, Mr. Chimanka accepts notice.
Yes. Extra copy may kindly.
Okay. Let's on. 15.
Obliged.
Item number 19.
Your Lordship. May I please, Your Lordship. Your Lordship, the delay is only 7 days, Your Lordship.
All right. So delay is condoned 15 of 20.
Your Lordship,
And
the
14 of
question-
20 dispensing with is also allowed.
Your Lordship,
Now,
the question of law is at page 16, Your Lordship. The payment, it is a contractor and the payment made to subcontractor and labor and service charges and all other things, Your Lordship, has been allowed without proper verification, Your Lordship. Your Lordship, so question number 1.
but these are concurrent findings, sir.
Your Lordship, at page 60, of the tribunal's order. Now the question is whether the deduction granted by the Law and First Appellate Authority and calculation of the TTU are correct or not. Your Lordship, so far as the deduction granted towards the dealer towards the cost of land used is unjust and improper, and the deduction towards payment made to subcontractor and the labor and service charges, Your Lordship, and that as regards to land cost, this is the finding as regards to land cost. The First Appellate rightly allowed the land cost deduction from the gross turnover, which is not a part of the gross turnover sale price. The audit official, after verification of the agreement, clearly admitted possession of land every year at the rate of 28% of the constructed house and reverse. Your Lordship, my notice may go, Your Lordship.
Why? You have to satisfy us.
And so far as the subcontract payment of rupees 36 lakhs, the dealer has given a registered subcontract during the assessment and labor and service
produce
charges.
details will.
Your Lordship, may kindly turn to the assessment order.
Yes. First appellate order also, same thing.
Your Lordship, first appellate order has allowed, and that has been confirmed by the Law and Tribunal.
Hmm.
And the assessment order at page 31. This is so far as the observation of in the AVR.
No, just come to page 48 bottom, sir.
Your Lordship.
Yeah, detailed discussion. Advocate furnished audited accounts. Furnished details of the bifurcation. Details have been furnished. That's there, sir. The present revision petition arises from an order dated 30th November 2019, passed by the Odisha Sales Tax Tribunal in essay number 34/5/2017-18, filed by the department for the assessment period 1st April 2011 to 31st March 2013. Paragraph. Among the questions sought to be urged for consideration by this court is whether the tribunal was right in affirming the order of the first appellate authority, allowing deduction to the dealer on account of payment to subcontractors, deduction towards labor and service charges, and cost of land. Full stop. Paragraph. It is sought to be contended that the above deductions were allowed without proper verification, and therefore this court ought to entertain the present revision petition and frame the questions as urged. Paragraph. It is noticed that both the first appellate authority and the tribunal have concurrently held that the dealer had provided all the necessary details to justify the claiming of deduction under each head, namely cost of land, payments to subcontractor, and towards labor and paragraph. The perusal of the first appellate order reveals that counsel for the dealer had produced the audited accounts and details of the bifurcation of labor and service charges, which has been set out in the order itself. Full stop. It cannot therefore be said that there was no proper verification of the books of account by the tribe before allowing the deductions as claimed by the dealer. Even as regards deduction towards cost of land and payments to subcontractor, full details appear to have been furnished. Consequently, this court is not inclined to frame the questions as urged by the discussed.
Item number 20.
None appears discussed.
Item 21.
May I please? May we be allowed to remove the defects within a week?
Or as a last chance, defects be removed within the list thereafter.
My name is not there. So
The name of counsel be reflected. All right.
Item 22.
22, there are defects, my lords. 1 year, 1 time may be granted to
Same order.
Item 23.
23, 1 time to comply the
All right.
defect.
Same.
Item number 24.
My Lord Justice Raman may not like to hear this matter.
Let's
Tribunal.
bench of which Justice Raman is not a member on 27 January.
But obliged.
Item number 25.
Item 25, my lords, I seek 1 week time to remove the defects, my lords.
All right. Defects be removed within a week, list thereafter.
Obliged, my lords.
26.
item 26. I pray for a passover by record is coming.
All right. All right.
Sorry, ma'am.
Item number 27.
None appears to the petition dismissed.
Item number 28.
Item number 28, Your Lordship, ASA was directed to obtain instruction, Your Lordship.
Mr. Padi?
Yes, my lord.
All these matters should be raised before the NGT. I think this is a fit case for NGT.
But NGT has disposed of on the ground that it is not an environmental matter.
I see.
You have filed that order.
Your Lordship.
NGT order was there.
But NGT said it's not
order
a matter.
Page number 36.
You better file reply, sir.
Instruction, but the order of the High Court as well as the NGT was annexed, my lord, by the petitioner.
That's right. So NGT is saying it is not within their domain.
If this remand is not maintainable, that's they refer to this court.
That's right. Say notice, then Mr. Padi accepts notice for office.
We have filed our counter that may kindly be noted.
One,
Copy may
five,
be served.
1 and 5.
Also.
Mr. Mohanty accepts notice for 2.
No, my lord, I have already filed the
No,
counter.
I know.
Please.
2 to 4. He states that he has already filed his reply to the petition on behalf of the
Opposite party number 9.
Drainage Division, bracket, opposite party number 9. Notice will now issue to the remaining opposite parties. You say Mr. Padi accepts notice. You
On behalf of 1 and
5.
1 and 5.
Correct. Notice will now go to the remaining opposite parties returnable on Fifth April. Replies be filed within 8 weeks, rejoined for the next date.
Deeply obliged.
Item number 29.
My lord, this case, my learned friend was mentioning, there is a connected matter. I also mentioned before your lordship, page 4 of the writ petition, that is WPC number 32762 of 21. Your lordship may direct that this case may be listed along with this, because same matter.
List along with writ petition civil 32762
of 2021. Tomorrow or Monday? Tomorrow or Monday?
24 January.
Right. My lord, next week can better, because there is this regarding that the connected matter is also important, because
No, is there a date given in that connected matter?
No, I don't know. But anyway, for 24th January.
24.
Okay.
Item number 30.
30.
May I please, Your Lordship? Your Lordship, this court was of the opinion that this matter should be referred to the NGT, and in the interest of justice, taking into consideration the financial capabilities of the petitioner, it is most humbly prayed that a direction may be given to the Tehsildar, opposite party number 5, to refer the matter to the NGT, which is in Calcutta.
Tehsildar will refer the matter. There is no such procedure.
Capacity of
go to the NGT.
In the capacity of public officer, Your Lordship.
No.
Why can't you go?
Your Lordship, these are for poor villages, Your Lordship, and the NGT is in Calcutta, taking into consideration their financial capabilities. It is prayed that the...
No, actually, I think filing the NGT is quite straightforward. There's no court fee also.
Everything is online.
Yeah.
And you can file it
online.
online, argue the case on online, and everything is now...
It's to do it.
You have to get out the house.
Your Lordship, the Tehsildar also has the power to...
No. Why Tehsildar? We don't feel that this is a case to be referred to. And why the Tehsildar will invite a case against himself?
Your Lordship, the State Pollution Control Board was also of the opinion that the case, that there needed to be an alternate way, and the way that was being used by the trucks is creating pollution. And this Honorable Court has also been of the opinion, which is why it is impertinent that being a public officer...
You've already We want petitioners to go to the NGT. Order dated 20th March.
Indeed, Your Lordship. The simple prayer is that the order may be given, direction may be given to the Tehsildar as a public officer.
How can it be?
Why should it be filed?
Abnormal.
EC counsel the petitioner seeks leave to withdraw the present petition with liberty to approach the National Green Tribunal in accordance with law. This post of is withdrawn with liberty is granted. All right.
31.
Same.
Same matter, Your Lordship.
Up to 33.
Right. Even that, yeah.
32 and 33.
That is
Supplementary list for orders 34.
Obliged.
This case has been filed return of the original orders, my lord.
that MC number. The return originals be returned, subject to be substituted. Attested photocopy. MC is disposed of. All right.
Item number 35.
So item 35, two number of defects are there. I have given the copy today. 35.
The defects you removed within a week, list thereafter. All right.
The other two defects may kindly be dispensed with. I have given the copy to the Land Council for
Okay, what is the matter about?
the GST matter. The appellate authority has confirmed the order of the
10%. How much have you paid as tax?
No. First appeal has been disposed of. Expert.
How much have you deposited? Did you deposit 10% of the tax?
That I found of the
Now,
instruction.
during the first appeal, you must have deposited 10% of the tax.
No, anyway, he has
So
not.
whether-
No, he has not filed any IA, nothing. All right, we'll simply say notice. He accepts notice. List on 4th May. Replies be filed within 8 weeks. Rejoined up for the next. All right. None appears dismissed.
And for the appeal.
All right.
Item number 37.
Let item 37, no instruction.
No instructions dismissed.
Item number 38.
Made your lordships. Whereas I find that today mission 23 is running very fast. By 11 o'clock, your lordship have reached 38. Of course, there is at 5 o'clock, chai pe charcha. It will be better, my lords,
Yeah.
if garam samosa is also served. Man, I have here, my lords, complaints to your lordships.
I've completed 2 years today. So
Yes, my lords. And again, we are fortunate to have your lordship.
Congratulations.
thank you.
You are fortunate that you have completed 2 years in our.
And everything has gone cool.
All right.
Very
Thank all of
good.
you.
My lords, lordship may kindly see
Yes.
order dated 22/10/2022.
Yes. That amendment.
Amendment I have already
All right.
filed, my lords.
All right.
Amendment may I filed the
Yeah.
and notice may be issued to 3 and 4 newly added
All right.
opposite part.
3450. That is for reasons stated therein. The application is allowed, and the amended cost title is taken on record. Then in the WC notice now it will issue to the newly added respondents. Returnable.
May praise short date, my lords.
Why? What's urgent?
Yes, it's all right. It's up to lordship's convenience.
1st May. 1st May.
Much obliged.
All right.
Much obliged.
All right.
Item number 39.
May I please your lordship, my lord.
Yes.
This is a appeal directed against the Honorable Single Judge in order in Annexure 5. There is a delay of 96 days, my lord, in filing the appeal, my lord.
What's the matter about, sir?
The matter about, my lord, a disciplinary proceeding was initiated against the respondent number 1. Respondent 1 accountable had been deputed to election duty in Tripura, my lord. After completion of the election duty, they returned back to their headquarters, Koiranga. And after they reached there about 6 o'clock in the evening. Thereafter, they have taken their meal. While taking their meal, there was a quarrel between the another head constable. Then at about 11:25 p.m. in the night, there was a firing. And that firing was from the AK-47 rifle, this respondent. 8 rounds of bullets were fired from that. And then the proceeding on 4 articles of charges were initiated against him. And there was an inquiry, and the inquiring officer found him not guilty. And then the proceeding was dropped. And on the basis of a statement of this head constable, in that proceeding, another proceeding was initiated only on the 1 article of charges, irrespective of these 4. Now, this in second charge sheet, the respondent appeared and filed his missions, participated in the proceeding. He was found guilty. Second suit, there he replied. Then he was dismissed from service. Then he preferred an appeal.
What was the charge?
Pardon,
what was that sole charge on which he was dismissed?
Second charge, my lord.
Yeah, what the charge against him?
Second charges, my lord, I have filed an IA for amendment of this appeal memo, because the grounds have not on few grounds I have taken.
Tell us, whatever you've
in
taken.
that amendment petition, your lordship may see, I have given the...
Let's see. What is the charge?
Earlier charges I will read, my lord.
Sir,
Article
when
1.
we ask you what is the second charge, don't read the
Second
earlier
charge, my lord, that the said number such and such head constable under suspicion of A company, 52 Battalion CRPF, while functioning as head constable during the month of November 1999 in A company, 52 Battalion CRPF, committed an act of misconduct oblique negligence of duty in his capacity as a member of the force under section 11(1) of CRPF Act 1949. In that he failed to ensure safe custody of his service weapon, bought number,
for which
body number,
for safe custody service weapon, you dismiss him from service.
No, he has
all
not only
disproportionate.
safe custody,
Disproportionate. If somebody grabs the runs away, he's responsible.
Well, it is not possible, my lord. That I have shown. The 8 rounds of bullet, each time he has
So
to...
that is over. That whole 8 rounds of bullet and everything, he has been exonerated totally. All right. That whole story is over. Now you're trying to revive that story. Again, starting another inquiry.
In that connection,
whole
my lord,
problem.
if the punishment is high, my lord, then that can be considered, my lord. But it cannot be said that the second proceeding is without jurisdiction or not maintainable.
The entire thing was gone into earlier.
My lord, that is
yes.
The discipline department. My lord.
This is like the double jeopardy. The whole inquiry is held and he's completely exonerated. And again, you start another inquiry on the same charge.
No, not my lord. Exactly.
Yes.
Not exonerated in other charges, my lord.
No.
He has quarreled with the other man. He has killed the...
It is all part of the same transaction, sir. There is no separate transaction.
No, maybe separate. Yes, my
same
lord.
Transaction.
Same transaction.
Same transaction.
But on the basis of his statement, my lord, I have filed in that IA his statement made in that inquiry, my lord.
Yes.
On the basis of that inquiry and his statement, we have framed the fresh charge. My lord, here,
we are hearing length, sir. We are hearing length. Not to worry.
My lord,
completely summarizes the whole thing. Yeah. You say the present appeal, it delays conduct. You say the appeal is directed against an order dated 11 September 2019, passed by the London single judge, allowing writ petition civil 2926 of 2005, filed by the respondent. Questioning. An order passed by the Commandant 52nd Battalion, Central Reserve Force, CF, Manipur, dismissing him from service. Paragraph. The background facts are that the respondent was appointed as a constable in the CRPF on March 1983. In 1998, he was transferred as head constable and posted at Imphal in Manipur. The allegation against him was that on 1st November 1999, in the late night hours, he had failed to keep his AK-47 rifle in safe custody, between him and his colleague Deep Singh, as a result of which 8 rounds were fired from his service rifle. This resulted in the death of Deep Singh and injury to the respondent, who happened to be hospitalized. Paragraph. Departmental proceedings were initiated against the respondent on 4 major counts. However, in a detailed inquiry held, none of the charges were held to be proved. After the respondent was completed on the departmental proceedings, a second departmental inquiry was again initiated. This time on the charge that he was negligent in not ensuring safe custody of his AK-47 rifle. In the second inquiry on the above charge, he was held guilty and awarded the punishment of dismissal from service by the order dated 30th April 2001. The appeal filed against the said order was dismissed by the Deputy Inspector General (DIG) (CRPF). And thereafter, he filed the aforementioned writ petition in this court. Paragraph. The learned single judge has in the impugned order noted that there were no valid reasons for initiating a second departmental inquiry on more or less the same charge after the respondent was exonerated as a result of a full-fledged inquiry held in the first round. Referring to the decision in State of Assam versus Jane Roy Biswas, year 1975 SC, 22. The learned single judge held that once a disciplinary case had been closed and the official reinstated, presumably on full exoneration, the government cannot restart the exercise in the absence of a specific power to review or revise the earlier decision. Paragraph. Having heard learned counsel for the appellant, the court is not persuaded that the impugned order of the learned single judge suffers from any material illegality. Indeed, the issue regarding the respondent allegedly being negligent in ensuring safe custody of the AK-47 rifle is inextricably linked with the chain of events where, according to the respondent, in the late night hours when he was asleep and it was pitch dark, he noticed someone running away with his weapon. If upon a full-fledged inquiry, all the charges against the respondent arising out of that incident were held not proved, and he was totally exonerated, it was not open to the appellant to restart another inquiry, to start another disciplinary inquiry on only one of the elements of those chain of events, namely the safe custody of the weapon. The learned single judge was right in observing that there was no warrant for a second departmental proceeding on the same set of events after exoneration of the respondent after a full-fledged inquiry in the first round. Paragraph. No grounds have been made out for interference with the impugned order of the learned single judge. Yeah, dismissed.
Your Lordship, I am appealing the respondent.
Yeah, the condoned.
At least the delay be condoned and the IAP allowed.
We have condoned.
Then the on merit, your Lordship has disposed of no, yeah, but the IAS may be disposed of.
It's already done.
Item number 40.
Your Lordship, I am for the respondent. My appearance may be noted.
All right.
Item number 40.
Item 40 was the defect I'll cure it within a week.
What's the delay?
My Lord, delay is about 60 days.
Delay is 137 days.
Sorry, my Lord.
Delay is 137 days delay.
Because after the judgment was received, I sent it to the bank. Then, in course of hearing, my learned friend has filed a Xerox copy of a judgment, which was not there in the bank. For the entire file, the file was not.
I applied for the certified copy, that was obtained, and I've given it to the bank. Then it was found that that judgment on which reliance is placed has no application to the facts of the present case.
We are not here to condone all this.
Here, the basic fact is that here the officer, after joining the bank in 1983, he misappropriated 3,100 rupees. He was placed under suspension. Thereafter, a charge sheet was issued. He admitted the guilt that he had misappropriated 3,100 rupees. The punishment was the fourth increment he'll get after 1 year, after 3 years. Now he accepted the punishment in 1984, did not challenge that. Thereafter came the NIT award. After the NIT award came, there was a fitment with the sponsor bank scales. Who will be fitted where? Now there was an anomaly. Wrongly he was given a fitment. And in that wrong fitment, about 10,000 rupees excess had been paid. And all others who were similarly situated, they refunded. But here in this case, he said that no, I am entitled to all those 4 increments which have been stopped. And the Honorable Single Judge said that even if the fitment is made, even if the fitment committee has said that there's an error, you cannot recover. But you will pay at the schedule or a chart given in Annexure 5. The impute order, if your lordship will see, page 41 of the impute order. My lord, the language of the penalty clause is that stoppage. One of the punishment imposed in stoppage means stopped. His increment for 3 years was stopped. It was not granted to him. The Honorable Single Judge held that no, it will be deemed to be cumulative, when the word cumulative is not there in the regulations. Now, as far as the Honorable Single Judge is concerned, kindly come to the operative part of the order. Page 41. When all that exercise before the Honorable Single Judge was based on the presumption that it will be cumulative. But it's not cumulative. He was debarred. He was debarred for 3 increments. Now, if he gets those 3 increments, the whole thing will turn topsy-turvy. Kindly come to page 41. Paragraph 27. Since this code, by order dated so and so, in miscase so and so, has paid for the recovery of the amount of Annexure 5, 10,000 was to be recovered in installments.
No, come to page 34, sir, para 19.
Yes. Yes.
He has accepted it's consecutive, not cumulative.
The word cumulative is not there in the service.
But he has not said it is cumulative. Come to para 19.
Yes. Therefore, there is no out of doubt. If the dismissal authority has imposed a penalty of stoppage of increment for the 3 consecutive years, and increment for the 4th year would be released only after the satisfactory performance, then in the 4th year, the petitioner having been satisfied with the 2nd year of condition, his pay has to be fixed accordingly. As it appears from Annexure 5, the order dated 7/6/95, after making a revised fitment under the NIT award and the working report on the RRBs, the benefit has been extended by fixing his increment as due and admissible to him on 1/9/87, that is at 850, as on 1/11/87, and at 100 at so and so and so and so. And the date of and the next date of increment is to be fixed in April. While such revision of fitment was made, no opportunity was hearing was given to the petitioner, and reasons for such revision of fitment has not been indicated in the order impugned, save and except stating that the fitment, benefits, and allowances given to the and on the basis of the NIT award, read with the working group report, are subject to revision and alteration, addition, if any, and any clarification will be received from the government of NABARD or the sponsor bank or any other authority
nothing has been placed on record by the opposite parties to indicate while revising the fitment, an opportunity of hearing was to be given to the petitioner because by virtue of the fitment already made, the petitioner answer 5, dated 7/6/95, was also receiving the benefits as due and admissible to him in accordance with law. Now, if your lordship have a look at Annexure 5 of this writ petition, which is at page 63. Sorry.
I think exactly the assessor. They were asking
This is the fitment made. This is the fitment made, which is accepted from 1980. Only after, and if at all this is worked out, we have paid according to this. That's all right. So in the operative parties order, last para, the Honorable Court said that you pay according to this, page 63, that we have paid.
Then why are you here, sir?
But here it difficult would be that page 18, sorry, page 62. Page 62 says recovery because we have wrongly paid earlier at 850. That 850, which was wrongly paid earlier, was revised to 550. And the Honorable Sigler accepts that, yes, this is correct. We'll pay around that. But if annexer, this recovery part has been washed, 10,000 rupees.
Correct. Because no natural justice, violation of natural justice.
No, as far as fitment is concerned, the NIT and the fitment committee said that if a punishment is awarded, it will also go into the fitment. Now, the punishment was stoppage of 3 increments. Punishment was stoppage of 3 increments. So if it is stopped, you cannot get it.
So 3 increments consecutively. That was the word used. You wanted to interpret it as cumulative. That was the whole problem.
No, I didn't mean it. I didn't say so. It was his case.
No. In fact, you're exactly understanding it the opposite.
No. The petitioner produced a copy of the order.
Yes.
In another petition,
yes,
which said, if you have not used the word cumulative, it will mean cumulative.
No.
But the language of our regulation is that simply stoppage.
You're completely understanding it to the contrary, sir. It was your case that it is cumulative. His case, it was consecutive.
Page 20.
Page 25, 26. You have not read it correctly. That's okay.
No,
you read it whichever way you want. It's all right.
The next thing is, if you're allowed to have looked at the last page, last part of the order, kindly come to page 41.
Yes.
I'll read it once again.
Yes.
In view of the facts and circumstances as well as the settled position of law discussed above, this court is of considered view that the order dated 7/6/95, so far as revised fitment annexure 5 and the consequential direction for recovery amount from the petitioner cannot sustain the eye of law.
That's because you did not issue any prior notice to him before revising it, sir.
Sorry. In the same breath.
No adherence to principles of natural justice.
Sorry, bro.
No adherence to principles of natural justice. That is the finding of the single.
At the time of fitment, each and every employee is not required to be consulted.
No. He's going to lose 400 rupees and you don't have to hear him.
No, my lordship kindly come to
son, one fine day, unilaterally you revise it. You have notice to him.
Could your lordship come to the next line? Next line. The petitioner is entitled to receive salary as per the fitment already made, wide fitment sheet attached to answer 5 dated 7/6/95. Read with the question committee recommendations. Now page 62 and 63, read together. 63 is paid. If he is paid according to page 63 at the rate of 550, the Honorable Court accepts it. That yes, that is correct.
This IA number, there's a delay of 137 days in filing this writ appeal, which has not been satisfactorily explained. Full stop. The court is not convinced that the reasons adduced in this application for the inordinate delay are bona fide. Full stop. Consequently, the court is not inclined to condone the delay in filing the appeal. Full stop. Paragraph. Nevertheless, the appeal has also been examined on merits. Full stop. It is directed against an order dated 12 September 2019 passed by the learned single judge, allowing OGC number 5613 of 1995 filed by the respondent. Full stop. In the said writ petition, the respondent, who was an employee of the appellant bank, challenged an order dated 7th June 1995 containing a direction to recover a sum of rupees 10,634.18 from his salary with effect from July 1995 in 15 installments at rupees 750 per month. Full stop. A further direction was sought to the writ petition to the bank to allow annual increments to the respondent for the years 1984 to 1987 and pay him the differential salary for the said years, and also allow an extra increment as per NIT award bracket minus bracket salary from 1987 to 1995. Paragraph. One of the questions that arose before the learned single judge was how the punishment awarded to the respondent in a disciplinary inquiry of withholding of 3 increments on consecutive basis should be interpreted. Full stop. The learned single judge has held that the word single quotes consecutive cannot be read as single quotes cumulative, but has to be understood in its plain, ordinary, and grammatical meaning. Full stop. Consequently, the learned single judge concluded that since the penalty was a stoppage of increment for 3 single quotes consecutive unquote years, the increment for the 4th year would be released only after the satisfactory performance. And that in the 4th year, the respondent having satisfied the second limb of the condition, his pay has to be fixed accordingly. Paragraph. The learned single judge also found that the downward revision of the pay of the respondent by the impugned order of the bank was in violation of the principles of natural justice, since the respondent was not put on prior notice. Full stop. In that view of the matter, the learned single judge allowed the writ petition and quashed the order of refitment of the pay of the respondent, and held that he was entitled to receive salary as per the fitment already made. Paragraph. Having heard learned counsel for the appellant and having examined carefully the impugned judgment of the learned single judge in light of the documents placed on record, the court is not persuaded that the impugned order suffers from any illegality that calls for interference. Full stop. There is no answer by the bank to the finding of the learned single judge that the refitment of the respondent's salary was made to his detriment without putting him on notice first. Full stop. Further, the interpretation placed by the learned single judge on the word single quotes consecutive vis-a-vis the punishment awarded to the respondent in the disciplinary proceedings, does not call for any interference. Paragraph. No grounds have been made out for interference with the learned single judge on merits as well. Paragraph. Consequently, the appeal is dismissed both on the grounds of delay as well as on merits.
Item 41.
Delay.
72.
Lordship, page AD not back from R1, R2, R3.
Someone has
The tracking report showing the item delivery confirmed. Okay.
Someone has also appeared, his name appears.
I see.
41.
All right. Sorry. Delay condoned.
I've given the similar order, your lordship has passed in similar matters.
All right. You see, despite service of notice, none appears for the respondents. And then same order. This the date will be now 27th February. (2023).
Item 42.
On behalf of Mr. Jenna, permitted to withdraw to file
Counsel for the
better
appellant
application.
seeks leave to withdraw the present appeal. This post was withdrawn.
My lord, 42, 43 and 44.
Same.
Same. Obliged.
Item 45.
My lord, there has been delay of 171 days, my lord, during COVID period, my lord.
What's COVID period, sir? Let's see. What was the day impugned order of the? What's the date of the impugned order?
Impugned order.
COVID. There was no COVID in 7/1/20.
7/1/2020. It is to file within 30 days, my lord. There has been thereafter in the month of March, COVID.
COVID started only in March. Anyway, what's the on merits? What's the case of merits, sir?
Fairly, I can say that I've got a very poor case.
That's what. So,
my lord. Even then, my lord, your lordship, here from 99 to when the respondent was working as a senior commandant, my lord, his promotion, he was not promoted to the post of DIG because of the CCR, which was taken into consideration from 99 to 2005. In every year, very good, the CCR, the entry of very good was taken into consideration. In 1 year, from 2002 to 2003, his CCR was good. Therefore, he was not taken into consideration. But since it was not communicated to him, there was that judgment relied by the Honorable Singles.
Correct. Devdutt.
Honorable Singles.
All right.
That is the.
All right. So
I've also given opinions in that don't file with that.
This is what is called statistical appeal. All right. The delay is continued. In the main matter, you say the appeal is directed against a judgment dated 7 January 2020 passed by the learned single judge, allowing writ petition civil 371 of 2006 filed by the respondent. Paragraph. In the said writ petition, the respondent had challenged a letter dated 14th February 2006 declining promotion to the respondent to the post of ADIG of the CISF with effect from the date when his junior in the cadre of senior commandant was given promotion. Paragraph. Apparently, during the period of review of the CCRs, although the respondent had got the grading of single quotes very good, unquote, in each of the years. In 1 year, that is 2002-03, he was graded as single quotes good, unquote, and that was sought to be relied upon to deny him the promotion. Paragraph. As noted by the learned single judge, the downgrading from very good to single quotes good was not communicated to the respondent, and therefore it was held that it could not have been relied upon to deny him the promotion. Full stop.
That was taken as adverse remark. That was taken as that.
Yeah. Refer to the decision in Devdutt versus Union of India, 2008 8 SCC 725, and Anil Kumar versus Union of India, 2019 4 SCC 276, where the legal position that an uncommunicated adverse entry in the CCR cannot be relied upon is well settled. Full stop. Paragraph having heard learned counsel for the appellant, the court is not persuaded that the impugned order of the single judge suffers from any illegality, which warrants interference. Full stop. Consequently, the writ appeal is dismissed.
Item 46. Item number 46.
Stand appeals for the appeal is dismissed.
47.
47 on behalf of Mr. Rao, matter is infructuous.
Or the appeal is disposed of as introduced.
Item 48.
Item number 48, my lord, these identical matters. The lordship, similar matters admitted and the interim order has been granted. The matter regarding that grant of benefit as has been decided in case of Sarath Chandra Parida. Here, my lord, the order was passed and without notice also.
I see. So on the very first day.
My lord.
Has notice gone in the present appeal? Not yet. Or
no notice has been given.
IA as well as writ appeal, you say notice returnable.
And so far the delay is concerned within that COVID period, my lord. 95 days.
Yeah, we'll condone it next time. You serve the other side. Notice returnable. 13th April. 13th April.
Along with that matter, your lordship may indicate. Along with that connected.
Along with writ appeal 324 of 2020.
Item 49.
May I please, Your Lordship?
My lord, in this matter, I am appearing on behalf of the opposite party. Today, I am just.
All right.
Your Lordship, Your Lordship, I have filed a revised and modified question of law, Your Lordship. This issue has already been decided by Honorable Supreme Court. Also, Your Lordship has decided. This is that surcharge issue, Your Lordship, so far as that Bajaj Auto.
Right.
Here, Your Lordship, the tribunal has passed the order cognizing the judgment of this Honorable Court in case of Bajaj Auto, which has been subsequently reversed by Honorable Supreme Court. So that is the question of law here, Your Lordship. Here, Your Lordship, the question of law, whether on the facts and circumstances of the case, the surcharge under Section 5A of the Odisha Sales Tax Act is to be levied after deducting the amount of anti-tax by the dealer pursuant to the Odisha Anti-Tax Act as decided by the Learned Tribunal, when Section 5A of the OST Act is a self-contained provision and is leviable on the tax payable under OST Act and the tax payable under the CST Act. This issue has already been decided by Honorable Supreme Court in case of that Bajaj Auto.
In favor of the department and against the...
In favor of the department. The Honorable Odisha High Court judgment has been reversed, Your Lordship, by Honorable Supreme Court.
My lord, the first thing is that the revision petition is filed beyond the period of limitation. Limitation has not been condoned. They have not moved an application for the condonation of delay. Application also not been moved.
No.
It is filed beyond the period of limitation.
No, there is no delay, Your Lordship.
Yes, Your Lordship, may kindly see the tribunal order is passed, which is the annexed, Your Lordship, at page...
What is the stamp report? I don't think stamp report says it's delayed.
No delay.
No,
there's no delay.
No, Your Lordship.
My lord, the order is passed on 31st October 2013.
We don't know how long it took to obtain certified copy. Now you move on to the next point.
The second thing is the assessment here, my lord, it is correct that the Supreme Court, Honorable Apex Court has already overruled the judgment of these things. My lord.
Come to page 27.
Your Lordship.
That is a memo of service.
Yes.
On the department. So that is in the month of December.
It's month of December.
So you compute 60 days from
60 days from that.
Yeah. The revision has been filed on 14th.
Yes, come on,
my lord. The second, the assessment year is of the year 2002 and 3, Your Lordship. And at that point of time, basing on the this honorable court's order, the tribunal has passed the order, which has been subsequently.
The law has changed now, sir. The same
that's I understand. Your Lordship has passed an order also in that and analyze that they cannot do it because the period of limitation is also over. That because the 5 years and 3 years, Your Lordship has already dealt with.
No, there was no list pending. Here it is.
It's a amount of only the 2,990.
No. If this will be dismissed, if the revision petition of the state will be dismissed, then I have to refund. Your state has to refund.
How much?
Your Lordship, more than 1 lakh, because the surcharge is to be calculated, Your Lordship, accordingly. And only after Your Lordship,
All right.
only the
Admit the following question is framed. There are 2 questions that top sheet, revised, modified question of law. Frame both those questions. Paragraph. As far as the first question is concerned, the matter is no longer res integra. Full stop. It stands covered against the dealer and in favor of the department by the judgment of the Supreme Court of India dated. Must be reported, sir. In Commissioner of Commercial Taxes versus Messrs. Bajaj Auto Limited, AIR 2016 SC 5014. Full stop. Consequently, question number 1 above is answered.
5014.
Yeah. In favor of the department by holding that the surcharge under Section 5 capital A of the OST Act is to be levied after deducting the entry tax paid by the dealer.
Before
Before deducting the amount of entry tax paid by the dealer pursuant to the Orissa Entry Tax Act 1999. Full stop. Paragraph. As a result of the above answer to question number 1, question number 2 is answered in the negative, that is in the favor of the department and against the SSC. Paragraph. The matter will now, the impugned order of the tribunal is accordingly set aside. The matter will now be remitted to the assessing officer to recompute the demand in light of the above in light of this judgment.
My lord, my name, baby. My name.
Gratefully, the revision petition is disposed of in the volumes. Right.
Item number 50. Item 50.
None appears dismissed.
Item 51.
None appears. May please your lord. This is the my lord PIL matter. Matter relates to installation of CCTV camera and firefighting instrument in SB Medical College and Hospital, my lord. This matter appears today's release as per order number 5 dated 9/11/2022, my lord.
Yes.
No affidavit.
No affidavit.
Last chance.
Last chance already my lord has given.
Final opportunity.
Final opportunity already been given in the order number 5 dated 9/11/2022. This is a very serious matter.
Safety arrangements in SCB, Medical College and Hospital.
My lord, I want to make small submission, my lord. This is a very urgent, my lord, serious matter, only because it relates to life and property, not only to the patient and attendant, but also all of us who are residing in the state of Odisha. Only because there is no fair safety arrangement in most of the hospitals and most of the government buildings, my lord.
Anyway, your prayer is confined to SCB Medical.
My lord, I am
all government buildings now.
No, my lord. As far as the hospital buildings are concerned, there is no fair safety arrangement, my lord. They have to file affidavit as per the order number 5 dated 9/11/2022.
Apology to your lordship. Last chance may be given.
Last chance already been given.
Costs, no costs.
Cost is a medical college, so not government. It is medical college.
You pay to the college itself. Cost to the college itself.
Yesterday we have deposited.
In fact, one prayer is that you still haven't sanctioned 95 lakhs.
Yesterday I have deposited 25,000. So your lordship, this time
it's from this pocket to this pocket as far as you're concerned.
No. In that we have deposited in High Court Bar Association. So 25,000 we have.
Your goodwill will go up now. All the lawyers will praise you.
No, but only 10 days. I undertake within 10 days I will.
Okay, if you don't file within that 10 days, then you have to pay costs.
Oh, obliged.
Despite an adjournment granted on 9th November 2022 to enable state to file an affidavit, it has not been filed till date. Mr. Devakanta Manti, the additional government advocate, undertakes that the affidavit will positively be filed on or before 16th January 2023, failing which
10th January.
16th January.
16th, failing which the state government will pay costs of rupees 25,000 to the SCB Medical College and Hospital by way of a demand draft in favor of the superintendent of the said college, and deposit before this court and place before the court proof of payment of costs. Full stop. If no such affidavit is filed, the who will remain present, sir?
Superintendent SCB Medical College.
Why, poor man? Why should he be present? Somebody.
Because
he's not going to file the affidavit. You have to file the affidavit.
He
wanted money. The prayer is that he had asked for 96 lakhs. You never sanctioned it. That's the prayer clause. So somebody in the health department.
Director of Health.
The Director of Health, Government of Orissa, will remain present either in virtual mode or physical. List on that other thing. (24th January).
Oblige, my lord.
Item 52.
May I please? The public PL regarding a public tank used by the people of Soroda NAC that has been dumped with waste concrete materials. Last two orders, your lordship wanted them to take instruction or file affidavit, my lord.
Yes, my lord.
It's over an area of 1 acre 77 decimal used by the public, and it's recorded for the public, my lord. And this honorable court is directed as an interim direction not to change the character, nature and character.
Last time adjournment was for instructions.
Yes, my lord, I have obtained the instruction from the Tahsildar and coupled by RI report. I have to file it in SEPOC affidavit.
What does it say? You can tell us.
My lord, yes, my lord. The RI report is like this. Soroda जलाशय भारत खाना आदेश पाई कई जने व्यक्ति द्वारा माटी और मोरम पूर्ण करुथिले. Somebody was feeling that brought by earth and moram and आपण सो गत स्वयं मुख्य ए विषय आलोचना सीमान थाना अधिकारी फोन माध्यम माटी न पके, and the local IIC instructed him not to do so, and a plot mati pokya potavale sarvasana apito, and there is also there is mentioned that the public is objecting if that land is fulfilled by it. This is the report of the
no
RI.
So they will ensure that it is not changed, correct? Because the apprehension was that they're changing the nature of the plots.
Your lordship may direct the Tahsildar to ensure in view of this RI report not to ensure if it is a government land.
That will serve the purpose.
And they take away the waste materials and renovate the pond, Milord. That can be used.
The Tahsildar has also given a
letter. By the time it was filed, 70% they filled up. I wrote a letter to the collector and Tahsildar. They didn't take any action.
No, the Tahsildar has informed that he has informed the IIC to take a necessary steps. Your lordship may dispose of by stating that the Tahsildar is to ensure that if the government
let them remove all the waste materials, make the pond applicable so that people can use it. That's the purpose.
Then let them remove the waste. You say the report, Mr. Manthi undertakes to place on record the report received from the Tahsildar. From the Tahsildar?
RI.
From the revenue?
RI Soroda Mandal. Revenue Inspector.
Revenue Inspector Soroda Mandal. Yeah. Along with an affidavit within a week with an advance copy to learn counsel to the petitioner. Paragraph. The grievance of the petitioners is that two plots 2487 and 2712 under Khata number 2020 of Moza Soroda are being dumped with waste material, thereby changing the nature of the plots which are actually a public tank. Full stop. Paragraph. In view of the report submitted today, which acknowledges that the local public have objected to the dumping of such waste, a direction is issued to the Tahsildar Sorada to ensure, with the assistance of the local administration and, if necessary, the police, that the 2 plots are cleared of all the waste.
Yes, ma'am.
And all steps taken to revive the tanks in question. Full stop. Photographs showing the removal of the plots with the waste having been removed be placed before the court on the next date. List on. February 16th.
May I pray your lordship to communicate this order to the local Tahsildar, so he will be more
Copy of
prompt.
this order be communicated forthwith to the Tahsildar Sorada by the registry.
District Ganjam.
District Ganjam. All right.
Item number 53.
May I please, your lordship? My lord, the PIL application challenging the executive infraction of the opposite party, the municipal corporation of the Puri town, my lord, not controlling the roaming dogs in Puri town, which caused the death of a 4-year male child in the bite of the roaming dogs, my lord. My lord, on dated 1/1/2016, while the 4 years male son, namely Satyabrata Raut, was playing inside the room.
Was there any inquiry undertaken, sir? Was there an inquiry report? You have just put newspaper clips.
Copy was served on the opposite parties, my lord.
Just newspaper clips will not do, sir. No reply filed, Mr. Monty, nothing. Where are the parents? Who are you, sir? Petitioner is what? Who's the petitioner?
My lord, petitioner is one of the advocate of this bar, my lord.
Sorry?
One of the advocate of this bar, my lord.
No, but what happened to the parents of the child? Where are they?
My lord, nowadays, my lord, the only son, my lord, the only son, my lord.
Where are the parents? You're saying only son. Where are the parents?
Parents, my lord, residing in the Puri town, my lord.
Who are they? Where are they? Why are they not in the court? Do they know you have filed this petition?
My lord.
Where are they, sir? Ask them to come forward. Are they interested in pursuing this petition?
My lord. My lord.
So ask them to come forward.
Oblige, my lord.
Counsel for the petitioner undertakes to plead the parents of the child who is supposed to have died as a result of being bitten by stray dogs in Jagannath Colony under Khumbarpada Police Station in Puri district on 1st December 2016. Paragraph, despite notice having been issued in this petition way back on 24th January 2017, till date no reply has been filed by the opposite parties. Stop. If no reply is filed on or before 27th February 2023, the collector Puri shall remain present in virtual mode to explain what steps have been taken.
My lord, may I submit
to control the.
My lord, actually this matter is to be dealt with by the municipality. He knows it, everybody. It is municipality who is looking after the executive officer. Municipality is to do the needful.
All right. But the commissioner then Puri.
No, there is no commissioner. He has
wrongly.
That is executive.
Executive officer Puri municipal.
By the executive officer.
My lords, two cases were filed in NHRC and OHRC, and pursuant to the direction, my lords, steps have been already taken by Puri municipality.
Where is that?
These two documents, my lords.
What steps were taken?
My lords, sir. That.
You appear for Puri municipality?
Puri municipality. That is executive officer that they
No. This is about sterilizing the stray dogs.
My lords,
what about compensation to this child? For this child's death?
Compensation part, my lords, that I have to obtain instruction because there is no provision.
That's the main thing, sir. That's why he's here.
There is no provision under the Municipal Act.
All right. If no reply is filed by the executive officer, Puri Municipal Corporation.
No, only
Puri Municipality. Sorry, Puri Municipality. On or before 27th February 2023, indicating what steps have been taken to alleviate the grievance of the parents of the unfortunate child as expressed in this petition. The executive officer shall remain present either in physical or virtual mode on the next date. Paragraph must be stated here that pursuant to the inquiries made by the National Human Rights Commission, the Puri municipality appears to have submitted an action taken report to the NHRC on 18th March 2017, indicating the indicating the number of stray dogs that have been sterilized under the Animal Birth Control Program. Stop. This, however, deals with only one issue, one of the issues, and not whether any compensation was paid for the unfortunate death of the 4-year-old boy. So, list on that. Ninth March. What is this? What is the grievance, sir?
Lordship, here is a huge calm, Lordship, so far in extending the benefits under the ODRP scheme. On the above, Lordship, filing, Lordship, cycle on filing, the state government adopted a scheme to provide housing facilities to the poor, Lordship. And now, Lordship, in this case, Lordship, given the Lordship Annex 6 series, Lordship, can see, they have extended the entire benefits to the rich man of the society, Lordship.
Can't have such broad sweeping allegations, sir.
Lordship, Lordship, kindly see Annex 6 series, Lordship, for a moment. We are given the entire figure, Lordship, of the district Ganjam.
What do you mean by rich and poor? There's no definition of rich. What is
But
rich?
Lordship, kindly see the policy itself, Lordship. Policy are available under Annex 1.
What do you mean by rich?
Only Lordship, rich means, Lordship, the benefits has to be extended only to the persons those have been having a thatched house. But Lordship, they have given the entire benefits having pakka house and more than 2,000, 3,000 square feet construction.
No, just imagine, then you will have to issue notice to all those people who you say are wrongly benefited. Because if your writ petition is allowed, their houses have to be taken
That's why
away
Lordship,
from
I
them.
made the party, the responsible officers made party, because
No,
that's
no,
why
no,
Lordship issue
persons,
notice to them to file a
individuals.
reply.
Those individuals who you say have been wrongly granted the houses,
Lordship,
they've all to be issued notice. They've all to be made parties.
That's why it is a public interest litigation, Lordship. We have,
of course.
Have not. That's why we made party to the vigilance and to crime branch, Lordship. Only Lordship, kindly see, had it been a case having Lordship fair practice, you Lordship issue notice since 2017. Till date, they're sitting over the matter.
That's one.
They're not intending to file a reply. Lordship.
No, but let's see where this is going. Assuming they file a reply, they'll say, no, we have done it all perfectly. Correct?
But Lordship, one aspect I can pursue, Lordship, because Lordship can say public litigation. It's only our duty to bring a Lordship's notice. What
That's
is
not
illegal?
No. It's not that you just bring anything and everything.
No. With Lordship, can say Annex 6 series.
No,
we have
you
worked
have to
out.
do it responsibly. You have to do it responsibly.
We have worked out, Lordship. Lordship, kindly see, we have made personal research on this. Lordship, kindly see. The petitions are
You don't
practicing
know
lawyer.
what is your criteria for rich and poor? I'm not understanding.
But
Who's
Lordship,
rich? Who's rich according to you?
That's why Lordship, kindly say Annex 1.
No, 1 minute. Who's rich according to you? You've put down some names. 150 names you put down in your Annex 6. Just picked up Tahsil wise or whatever. GP wise, you've some in one GP, Sana Ramachandra, you have put down how many names? 17 names.
Lordship.
You have deemed all of them to be rich, according to you, right?
Lordship, kindly please page 29. They have categorized, not Lordship.
What?
Page 29, the policy itself, Lordship.
No. So did you go to each of these 17 people? And,
yes, Lordship.
No. Did you ask them what is your income? You're like an inspector. You're an income tax inspector. If you ask them what is your monthly income or yearly income, there has to be some criteria. It can't be arbitrary.
Yes, that is my entire
No. If you are
my humble submission, they have disturbed their own criteria, Lordship. Lordship, kindly page 29.
That these people do not meet that criteria. On what basis have you decided?
Yes, Lordship, kindly page 29. Lordship, that is their own guideline. Lordship, I am coming to that. Lordship, page 29, eligibility criteria.
That's
If
right.
Lordship,
but on what basis did you find out that these people whom you have named in Annexure 6 did not meet that criteria?
Lordship, kindly see just eligibility criteria class B, Lordship, kindly see.
Yes.
The beneficiaries shall be those families who fulfill the following criteria. Ordinarily resident of the state of Odisha. Their houses are located within 5 kilometers from the high tide line STL in the target districts. Their houses were damaged beyond repair by cyclone Phylline and associated rains and floods. So this is very important, Lordship. Then 4, houses that may not have been damaged but are vulnerable to hydrometeorological hazards and are unsafe for contained occupation or those in untenable lands. So, Lordship, kindly see my application, my observation. Those persons having Pakka house.
How did you know that, sir? What was the basis of this inquiry? How have you simply named some people?
Because Lordship, I have personally visited. That's why I made party to the state
Personally
authorities.
visited means you met all these people. You actually went to their houses and met them.
It is not possible to meet the people, but
you're a great public interest litigant, sir. You're fired by public interest, so you are acting very responsibly.
But Lordship,
you're not simply naming anybody. Tomorrow, I don't like this man's face, I'll include him in the list.
That's
it can't be that way, no?
That's why I made party to the government officials.
No,
And Lordship, consider my submission, Lordship, issue notice to them.
No.
Only had it been a
Mr.
case.
Dalai, the two of us implicitly believe that whatever Mr. Dalai tells in court is 100% truth.
No, I am not saying that.
No, we have to. When Mr. Dalai comes with the PIL, we have to believe that everything that he's saying is 100% true.
But this is public.
No, we have to know because you're coming in public interest. We believe you completely.
Lordship.
And we allow your petition.
Not allow, Lordship. Lordship, issue notice.
You don't want the petition to be allowed.
Lordship, issue notice.
You want the petition to be allowed.
No, I am not on that, Lordship.
Why? We are on that, sir. We are very keen that your petition should get allowed.
Lordship, now.
No. We are finding out how to allow your petition. Correct?
Lordship, in fact, Lordship.
We are also looking at what will happen if you allow your petition. What will happen? All those people you have named in that Annexure 6,
Lordship,
they'll have to lose that houses.
They have already constructed, Lordship.
No. So they have to either...
They can't, Lordship. They have to...
I am on the issues of public money. They'll at least have to go out of their houses.
No.
Then the deserving people have to come into those houses.
It's a misuse of public money, Lordship. There's huge misapprehension, Lordship.
No, correct, sir. Correct. We are looking at what the next step is. Because what will happen if we allow your petition? Those people will lose all their houses.
No. It cannot be, Lordship. Because
why?
Because it will create another cause of action, Lordship.
Correct.
I am not on that.
Now you're on the correct point now. But you have to be on that.
But my humble submission, I am
what is the consequence of allowing your petition?
But Lordship, my humble submission before Lordship, let them file a reply so that we can
take it to a logical end, sir. This filing reply, rejoinder and all, where is it going to take us is the question. Yes.
At least the officers should not repeat further, Lordship, because Lordship kindly see this is Odisha.
See, you have become prosecutor, judge, everything.
Lordship definitely.
See, this is what PIL means. You have to do homework. It's a lot of work.
Yes, we have done, Lordship.
That's not the homework, sir. You have to then tell us on what basis you picked up 17 people from that GP and left out the other people.
Because those are, as per the petition, Lordship.
As per what criteria? Did he ask them, what is your income, sir? Then he determined that he's a rich man and poor man. How did he determine that? Who did that inquiry?
That's why, my lord, they have
you will make an allegation and they'll go around searching for the truth. Cannot be.
No, they have made criteria.
You have to first of all discharge your initial burden of establishing some facts. Correct? Not on the basis of newspaper clippings, which is why we don't go by newspaper clippings.
No,
we want some preliminary inquiry, some homework, something to be done.
That's why Annexure 6 series, Lordship, kindly see it.
That Annexure 6 is not a responsible exercise, sir. It is an exercise. Every GP, you've picked up some 20 people, you put down their names.
I have picked up a lot of many people of the entire district. Lordship.
One person, you say both his sons are working in central government, correct?
Lordship.
So every person whose sons are working in central government is a rich man. Is that right?
Not rich man, stable, Lordship, in the society. They are stable. They are.
Are you sure of that? Do you know the number of? Have you been to the old age homes, sir, in Orissa? Mr. Dalai, because you are a public interest litigant.
Lordship, I have read.
You should visit old age homes in Orissa.
And also staying in old age home, Lordship.
That's right. Have you visited how many destitute old people are there whose sons and children are not only central government, staying abroad? Are you aware of that, sir? You're not. You are. So just labeling because his sons are working in central government, he's a rich man. It's the most dangerous kind of. See, as lawyers, we don't have the privilege to be arbitrary, sir. But every day you're arguing in court how people should not be arbitrarily acting. No, you're saying government is arbitrarily acting. That's why justice must be done. We ourselves should not be arbitrary. Our criteria must be foolproof. Our homework must be foolproof. Then if the court is convinced that you've done that level of homework, then we will be satisfied, we will be assured that you've come with a solid petition and you've responsibly done your homework, then we'll entertain it. No difficulty. Otherwise, we'll just be going round in circles, not finding any resolution.
But Lordship,
and we'll be hurting more people than we think we're rescuing.
But Lordship, because
many of your colleagues will be very happy because those 100 people or 200 people in that Annexure 6 will all run to your colleagues only. They'll say, we've got notice from the court. Then this one courtroom will not be enough.
There are lots of pressure also.
PL, that's a danger in the PL. If we start entertaining all PL like this, then this we have a huge problem in our hands.
Lordship, absolutely correct. Dangerous PL, Lordship. The petitioner getting threats from every corner, Lordship. So,
no, and you can make terrible mistakes in this.
In 2017, had it been a case on because Lordship,
we have unnecessarily listed all these matters because they're all lying in our registry.
Let's give me room, Lordship, that I can approach to the vigilance, Lordship. Lordship say it will suffice, Lordship.
All right. Counsel for the petitioner seeks leave to withdraw the petition. With liberty to seek other appropriate remedies available.
Lordship,
in accordance with law.
Instead of others, Lordship, specific person, I can approach, Lordship.
Then, otherwise, see, we are beyond the stage of free legal advice. So, you're all very learned, noble profession. So, you know the best thing to do.
Lordship.
All right.
Item number 55.
In this case, government is filed as per the direction of this Honorable Court dated 23rd of August 2022. Counter has been filed, but it is contradictory to the counter filed earlier, as it will be revealed from page 61, 60 of the writ application. But the party, the petitioner, could not come to, due to post-harvesting time, he could not come to file the rejoinder. It is an attempt to take the government property where the RI office admitted fact, RI office and the hospital, that is Ayurvedic hospital is running, admitted by the court. Now, in the meantime, what has happened? Now the government has filed just 2-3 pages counter affidavit stating that now it has been recorded in the name of so-and-so, that person against whom we are approaching, that he has managed to take the property being the sarpanch of that area. Now the ROR has been published, that has been filed by the government. Because we are filing objection that here it is Matrumangal Kendra and that RI office is there. We are approaching to the Tahsildar. don't record it. But so many cases are pending, but this is being recorded when the case is pending, so that it will be clear to your lordships. Well, if next week it may be listed, the party will come and file an affidavit.
No, there's an RI office on that land now.
Yes, 6061 RI office and Matrumangal Kendra, that is running. My case is that has been sold by that Dutiya Rana, that has been sold by some other persons to him. And the cell deed, there is mentioned that no construction is there, but 2 buildings are there. And that is government filed counter that yes, that has been repaired from 1963 with the funds of the government.
No,
but now
RI office is a government office only.
Yes, that is being renovated. And that property has been sold. Now it's page 60, 61, your lordship may see. We are filing that their cell deed.
No, it's still functioning there. Where are you saying? What are you reading? Come to para 3 of the counter affidavit. It's functioning there.
Yes. So that is a step that has been now sold. The cell deed I have filed. So that cell deed should be rejected, cancelled. And cell deed also, there is no mention with regard to this. It is a connivance of this, some government people along with some land mafias to grab that property. And they have taken it. And now what has happened, your lordship will be surprised when this writ application is pending. Now in the year 2021, that Sarpanch has donated some of the land to the again BDO. That paper is there, but the party has could not come. So that rejoinder affidavit is necessary. I shall file next week. It may be taken up. The villagers are fighting for the cause to protect the government institution. But the government is not trying, and in connivance, they are giving that property. Not taking any steps. Rather, ROR has been published in his name. Next week, my lord, it may be taken.
No, what's the factual position?
And the actual position, what I have gathered from the counter affidavit filed by the Tahsildar, that the ROR was in his name and he purchased it by annexure B/3 and C/3. These are the things, and the office is functioning over that.
That's right. The RI office is there.
Yes.
Matrumangal Kendra means what?
That is maternity center. Maternity center.
Some medicines are being given in villages.
So that is functioning there only.
Yes. And that has been sold. How that government property can be sold? And now during the pendency of the case, now that has been mutated. And we are making is
just see the previous order that we've seen past 17 November order.
Yes.
No, sorry, the earlier order, 23rd August.
Yes. In the affidavit filed by the Tahsildar, it is stated that if it is found that plot number 8 is government plot, immediate steps should be taken to declare the cell deed as void. No steps.
No. Government plot, it is found that it is private plot. Para
in the meantime, that has been recorded. From the beginning, it is not.
Para 5 of the counter.
Page 65, your lordship may see.
He is saying that
is there.
Yes.
Subsequent RI report cannot take away the previous one. 65 page. Your lordship
if at all he is challenging that a particular cell deed is void, then he has to approach the civil court. That is what my stand is.
It is not.
I think what the plea is that government property is being sold.
Yes.
Sold. Yes.
But how can you allow, you are the government, how can you allow your property to be sold to somebody else?
I come forward with a counter affidavit that this is the ROR, this is the cell deed.
Are you not interested in getting the sale deed cancelled then as a government?
No, it is prima facie, it is not a government land. He is showing some antecedent of the title.
No. If your office is functioning there.
Now, thereafter it is gifted to government, which now my learned friend is saying that he will submit those documents. Currently it is but some transaction in 2012, your lordship may kindly imagine, some cell deeds of 2012, by filing a PIL, he is trying to nullify it. Only reply which I have given that These are the matters to be dealt with by the civil court.
No. But earlier affidavit that you had filed, the Tahsildar's affidavit, you had said that if it is found to be a government plot, then you will take steps to cancel the sale deed. That's what you had said.
No, it is there. The
council changes, affidavit changes.
But in the next counter affidavit, we have stated that it is found to be a private land. But so far as even your lordship, liberty is always available to the party.
Just come to page 61, second paragraph.
61.
After knowing the fact from the report of the RI.
Where it is counter online. Petition, page 60. My lord is referring page 61 of the writ petition.
Of the writ petition?
Yes, my lord. Sorry.
Your counter
From
affidavit
60, the last paragraph.
your counter affidavit 2nd December 2014.
Yes, my lord.
There.
Yes, my lord.
There, internal page.
Yes, that is there, your lordship. That was also indicated in the last year.
Order.
Yes, last order.
What have you done? Once you found out whether 367 is a government plot?
Yes. Subsequently, it is the subsequent affidavit reveals that it is found that it is a private plot recorded in somebody's name. That is why we did not. But if at all he is agreed by that, that is also written in my counter affidavit. He is at liberty to approach the appropriate court of law.
No, but are you not interested? The question is that you got your buildings there and somebody is selling off. Tomorrow you will be evicted.
No. Yes. Now it is very much there in our name. That is also admitted by
name meaning what? No. 367 is in your name. No. You better find out, sir. I think you're not. There's no clarity on this.
Let my learned friend file the rejoinder. I will file a better affidavit.
No. Information should be given by the government because government is supporting that. Government, in connivance of the government and some powerful persons, the government property is being trying to be taken over. So that we, the
is
people
it government
of
property?
Lachipur village.
Then the question is it government property at all?
Yes, my lord. That is
where do you get that?
Proper inquiry.
Where do you get that? Where are you getting that it is government property?
Actually, what has happened, my lord? In their counter affidavit, also para 58, your lordship will see that the property was recorded in the name of two persons, that is Rukuni Patnaik and this Dutiya Rana. And Rukuni Patnaik, she filed a case against the Dutiya Rana. Your lordship may see that title does not title is not same. That is also manipulation is there. Rukuni Patnaik filed a suit that yes, this before the consolidation officer also this with high-handed action, this person recorded that land in his name along with Rukuni Patnaik. Then Rukuni Patnaik filed a case, then she died. And most probably there is something that she has donated to the government or something like that.
Don't guess. This is all becoming...
May I suggest one thing to my lord?
But the people of this Lachipur village, they are enjoying the service from that Matrumangal Kendra and all. Then when the property was again, what has happened? 2012, again with connivance with some government officials, now that Dutiya Rana could get the property in his name by purchasing it from most probably that adopted son, claiming to be adopted son.
She is not clear.
That is not correct.
We
are only.
May I suggest one thing to my lord?
Not be sold.
My responsible submission. Now the office.
Why government is protecting the?
I am not protecting. I am saying something in your favor. Try to understand. Have patience. Your lordship, now the offices are functioning. She is alleging that there is some manipulation in the records, and your lordship may direct collector or higher authority RDC to have an inquiry in the matter.
after hearing the petitioners and take necessary steps and dispose of the writ petition. That is better. If he is agreed by that decision, he will come and...
Pillar to post, the petitioners.
No, not pillar to post.
In spite of these High Court orders also, they are daring to record the name of the party during the pendency of the case 2021. When the case is pending and we are not getting relief from
RBC
anywhere,
is the highest authority.
Government is filing that it is recorded in their name. It was not recorded in their name. Government cases, it was not. Now they allowed it to be, then they are ratifying the defects. Yes.
No,
that my lord, government's admission.
What
that
admission?
Yes,
No.
in that property it is running. That
Madam, because something is running in a property does not become the property of that entity, right?
but it is also not the property of that person.
Your entire petition is based on the assumption that this plot belongs to the government, correct? Is there any scrap of paper or document to show it is government property?
Then your lordship may also think from admission is 63, it is running government.
Doesn't
then adverse possession
you're complicating issues. Actually, you might end up achieving a result which you never intended to achieve. If this inquiry shows that this is actually a private property on which government is running a building without paying any scrap of any compensation, that person will start demanding compensation from the government.
Yes.
And he will say, if you can't pay compensation, you cannot encroach on my property, out you go. And this
to the light.
No, you want that revenue office in that Matrumangal Kendra to function.
Yes, madam.
If it is found it is not government property, they will have to cease functioning.
No, that is also not the property of that.
How does it help you? If it is not government property, it belongs to some private individual. How does it help you?
My lord, they have
don't work at cross purposes. This is the problem. This is the problem again. Everything is projected as PIL without doing any homework. Just making allegations.
That is what I'm saying.
All the proofs are
they have got some personal difference with the practice.
It's not cooperating. Your lordship may see Annexure 1. Annexure 1.
And
I have filed, that is the court's order. That Rukmini Patnaik filed a case against this Dutiya Rana, that encroachment against the consolidation officer that wrongly recorded in the name of Dutiya Rana. But he is having no legal heirs.
And they're scoring points.
And there are papers to show. It is the property of some other person does not mean it has been taken by playing fraud. Some other person has taken away with the connivance of the government officials. It is clearly shows. Your lordship may put it in next week's Monday. We'll file the rejoinder affidavit. If the next week, your lordship may put it, they will file the rejoinder showing that.
The present petition was filed on the presumption that property belonging to the government, that is where an RI office and Matrumangala Center are functioning. In plot number 367 in Khata number 245 by 26 of an extent of AC 0.400 decimal in Mauza, Lachipur. District Zone 4. Is in fact belonging to the government. So the further presumption on the basis of which the petition was filed is that certain private persons are seeking to have effected sale of such government plot illegally, and that no steps are being taken to cancel the sale deed. Full stop. Paragraph. In the initial reply filed by the government, on behalf of the government by the Tahsildar, bracket I/C bracket Sonpur district, the stand taken was that in the event it is found that plot number 367 is a government plot, then steps would be taken to have the sale deed declared as void. Paragraph. A subsequent counter affidavit has been filed on 14th October 2022, enclosing a field verification report indicating the names of some private individuals in the ROR vis-a-vis the plot in question. Full stop. No doubt those entries reveal that there is an RI office and a Matrumangal Kendra operating from the said plot, number 367. Full stop. Paragraph. There is therefore nothing to show that the plot as such belongs to the government. Paragraph. Counsel to the petitioner, however, insists that the matter should be properly inquired into, as certain individuals may have got a sale deed registered illegally. Stop. However, counsel to the petitioner is unable to show any document which would indicate that the plot belongs to the government and not to private individuals. Full stop. Paragraph. In the circumstances, the only direction that can be issued by the court is that the inquiry can be by the Tahsildar himself or the collector.
No, my lord, because Tahsildar has filed the
collector.
Even if you're to satisfy my learned friend, your lordship can direct the RDC. He is the highest authority of the division. RDC Sambalpur Northern Division.
All right. The
Some papers
Revenue
are
Division
filed.
Commissioner,
He will
Northern Division Sambalpur, to
When the case is being here, it is pending. Some another mischiefs have been played by.
no. Let's just give this back.
Yes, my lord.
No,
Those
no,
documents.
No, it's all.
I wanted to file that in.
No, it's not even
Richard-
translated. It's all. Just give this back. Right. To conduct an inquiry into the matter after issuing notice to the petitioners as well as opposite parties.
Private opposite parties are
Opposite parties.
And the
5 to 13 as well as the
Tahsildar
Sonpur.
Hello,
And if the result of such inquiry reveals that plot number 367 belongs to the government, then to take appropriate steps.
Yes, ma'am. Yes.
As warranted in law. Paragraph. A copy of this order shall be sent to the RDC.
RDC Northern Division.
Northern Division Sambalpur forthwith. The above inquiry be completed within a period of 6 months from today.
Obliged.
My lord, prayer
The
portion.
petition is
italic
disposed of in the above terms.
Prayer portion italic 2. That should be the purview of inquiry. Your lordship may see prayer portion italic 2. I have
Your lordship has given the entire
that
things
is
to
the
be.
crux of the matter, my lord.
He will
Because
respond.
that inquiry is a matter by an independent agency regarding illegal sale of the land by the alleged legal heirs of Rukmini Patnaik,
Item
and
56.
sir, the property was donated by said late Rukmini
Item
Patnaik
56.
to
Item
government.
56. I'm in VC, my lord.
Yes.
This case is with regard to the setting up a PET CT scan in different cities of Orissa, my lord.
Right.
As per the last order, the Cancer Institute at Cuttack, they have already installed. And you'll kindly see the order dated 12th of April 2022 for a moment, my lord.
Yes.
12th of April.
Yes.
Second paragraph. Mr. A.P. Das, Learned Additional Standing Counsel for the state, needs some more time to update the court on the current status of procurement of equipments for the medical facilities at Baleswar and Berhampur. Apart from the rest is not important. So now here the state government took time on 12th of April to give the exact status as to how much time they would be requiring for procurement of the equipments for this Baleswar and Berhampur. Then subsequently immediately on the next date, they took a different stand. They say it's not possible for Baleswar and Berhampur. Then your lordship may kindly come to the order dated 19th of October. That is the last order, my lord. I'll just read out the last line from the first page. However, the affidavit
is silent. Affidavit is silent on why the transportation of the radioisotopes cannot take place from Bhubaneswar by road, which should take even less than 4 hours. And the next para, my lord, for a movement, another one submission. Disconnect. Para 5 of 29/4/2021. As regards establishing similar facilities at Capital Hospital, Bhubaneswar and Jharsuguda, it is stated that the facility at the aforementioned 2 locations will be made operational by April 2023. Now we are January 2021.
October, your lordship may just kindly go through. However, the affidavit is silent on why the transportation of radioisotopes cannot take place from Bhubaneswar by road, which should take less than 4 hours. So now they were to file an affidavit. So far they have not filed any affidavit as per my last instruction, ma'am.
Yes, Mr. Sabatha.
Mr. grant me because which time I've got the instruction, I will file it.
Mr. Samantra states that he will file an affidavit. In terms of the order dated 19th October 2022, possibly within 2 weeks. List on. February.
May I submit one more thing? And as far as the Bhubaneswar and Jharsuguda, they stated that it will be operated by April 2023. Now we are in January 2023. 2 months left. To that effect also, they also filed the status of the 2 stations when they will start it, my lord.
All right. The affidavit will also indicate the status of implementation of the provision of such facility in Bhubaneswar and
Jharsuguda. By April 2023, they are admitting. My lord.
My lord.
To that effect, we also filed the affidavit, my lord.
My lord, some commission to make. May I be pardoned? No reply. I am appealing for the opposite party number 3.
Now it's not necessary, sir. Your facility is now functional.
My lords, that's why I am praying.
Yeah.
My presence is not necessary.
No, sir. You can always switch on a camera. That's all you have to do, sir.
Grateful to Mr. Devasith Panda that Cuttack, even if late, still operated and benefit for the poor people.
Correct.
And Cuttack town, the disease like cancer.
Thanks to this petition that came up. And they responded well. I think Mr. Panda's client has responded well. I think it's one of the landmarks.
We have taken steps.
I'm greatly obliged to Mr. Panda and Mr. Your Lordship and the petitioner.
Suddenly is very brief.
Yes.
My lord, I have a small submission to make. No reply has been filed as per para 5 is concerned in my miscase, my lord. That will also file. That I will also file.
Item 27 February, my lord. 27th
February. That's right.
Oblige.
All right.
Item 57.
Here, government had taken time to file reply. Also, private opinion.
My lord, I am appearing from OP number 5 and 6. Some time may be given to file counter, my lord.
We will also file a counter.
All right. Replies be filed within 8 weeks. Rejoined to the next.
Lordship, make it last chance. Because twice they have taken.
Okay. As a last chance.
Replies. Because it should be before 31st March.
Like 8 weeks.
Lordship was renewal of license of SOP is concerned.
All right. 8 weeks. List on. 2nd May.
Smaller. I pray prior to 31st.
It's all right.
Item 58. As item 58, I filed my.
1 week time may be allowed.
As the only
File agenda.
difficulty is there's a status quo order operating against me. I filed my.
What is the matter about?
Well, as this pertains to displacement of certain individuals due to the Lower Suktel irrigation project. And my lords, their grievance was that without issuing RORs, they were being displaced, which is why my lords was pleased to grant the status quo. And my lords, I filed my counter affidavit. My lords, may kindly peruse page 2, para 5, my lords. So about 111 families were identified, out of which 91 families have been allotted the plots, and in fact RORs have also been issued to all 91, and some of them have actually collected the RORs also. So there is no impediment with regard to their constructing houses in the displaced plot. With regard to the other 20 millers, they opted to get compensation. And consent was taken from them that because as per the sanction order, they can only be displaced after the money has been, the compensation has been paid. So consent was taken that we are giving you money, although you have not displaced, but still we have given you money, and there's a consent they have signed that they will displace. So with regard to these 111 families, millers, the R&R exercise is complete. And this is millers the first phase. And then there is second phase, and there'll be subsequent phases. But the petitioners here are only concerned with this first phase because...
So they basically wanted time till April 2023 to vacate.
Please, millers. Millers, there was a eviction drive on 14th of November.
That's why they came to the court.
That's why, millers, they had come to court. And on that particular day, millers had passed the status quo order. And now, millers, I think this affidavit is clear. Millers, page 3 of my affidavit. The first paragraph, if I'm...
So I think give them time till 31st March, at least.
Please, millers.
You can give them time till 31st March. I think we won't, because that's the main concern. They wanted till end of April, give it to them till end of March. You see, the petitioners had approached this court apprehending displacement as a result of the Lower Suktel irrigation project in Bolangir, and had sought time till end of April 2023. For vacating the acquired land. Full stop. In view of a demolition drive that took place in November 2022, they filed the present petition, in which, while issuing notice on 14 November 2022, this court directed status quo to be maintained by the parties as regards possession. Paragraph. A counter affidavit has been filed by the project director R&R of the project, where inter alia, it is submitted that pursuant to the R&R policy, rehabilitation assistance was extended to 111 displaced families in the first phase by an order dated 23rd March 2022. Full stop. Of these, 91 displaced families have already been allotted plots in Larkipali and Sadaipali R&R colonies on 1st June 2022 through the plot allotment committee. Full stop. 20 displaced families of the 111 had not opted for taking plots and were paid compensation in lieu of the homestead land owned by them. So these details have also been placed on record. It is stated that R&R payment is being disbursed to displaced families on the basis of the written consent to vacate their houses within 7 days from the date of receipt of R&R assistance. Full stop. Paragraph. In view of the above factual position, and considering that the petitioners have sought for some time for actually vacating the plots, and with a view to avoiding any forcible displacement, a direction is issued that those who've opted for the plots and even those who have opted for compensation will not be disturbed till end of March 2023, by which time they would give written undertakings by way of affidavit. No, subject to their giving affidavits of undertaking that to the project director R&R not later than 16th January 2023. They would peacefully vacate the plots in question on their own on or before 31st March 2023. Full stop. If no such affidavit is filed, this interim protection will not be available to such persons. Full stop. The writ petition is disposed of the above terms. All right.
Item 59.
May I please, Your Lords?
59.
This is a matter challenging 148 notice matter, where this annexure 1, which has been as per satisfaction joint commissioner, which is supposed to give
one time because I don't have any brief. If it's not correct, it will be covered by your Lordship judgment.
Yes,
I will give 3 days
Lordship.
time so that I take instruction on this and keep a copy.
All right. The request to Mr. Satpathy, standing counsel for the department, list on 16th.
9th,
16th January. All right.
I don't know, 60.
Copy.
No, it's not 16. Sorry. 17 January. 17 January.
Copy of the petition.
Copy the petition, sir.
Item number 60.
Flood 60 is the case, my lord. These goods are covered by the Lordship and the additional excise duties, my lord. Earlier, my lord, audit assessment was completed. My issue has been approved, my lord. That is, yes, it is a ADJ goods, my lord. No state tax will leviable. Then, my lord, 43 has been initiated. My lord, by your Lordship, see the Annexure 3. Annexure 3, this is the notification of the government. Government has clarified that as it is continuing, no tax will be leviable. So far as the taxable textile goods is concerned. Your Lordship, see the internal place 12.
No reply filed, nothing?
No, my lord. Interim order is there, not.
No, Lordship. Your Lordship, what happened here, Your Lordship? It is the assessment after 1/4/2006, 1/3/2006. So as per entry number 113, the textile products are not taxable since these are taxable as central excise, Your Lordship. So after 1/3/2006, by notification number 11/2006, that became exempted so far as that excise is concerned. So it is taxable as per 113, Your Lordship. And since this assessment is after 1/3/2006, it is taxable.
Now, what about this clarification?
Your Lordship.
Central government has clarified. The position stands as
Yes,
such.
as it is.
Your Lordship,
that position as it was. And you are the participant in the divisible pool.
And is getting 1% from this central government. And explanation is very clear now.
Textile, tobacco, and sugar. 3 items. Goods of special importance.
But Your Lordship, let me take a small instruction only on this.
You see,
because Your Lordship, I'm well aware.
In para 2.
I'm well
It's
aware.
clear that from the above government of India,
Your Lordship,
application number such and such, which you are referring to, even though exemption was there, does not change the earlier position in any manner whatsoever.
So it does not become amenable to sales tax. That position continues. We'll
Passed earlier, similar or passed in my.
Correct.
In Sri Mandira case, Lordships have dealt with it.
Right. You say
No, that is prior period. That is prior period.
1/3/2006.
Yeah.
Yes, yes. That is covered
Sri
by.
Mandir. Sri Mandir.
The challenge in the present petition, it's an order, assessment order dated 18 July 2016, passed by the Deputy Commissioner of, passed by the Sales Tax Officer, bracket STO, Mayurvansh, Circle, Baripada. Raising a demand and consequential penalty. For the period under Section 43 of the Orissa Value Added Tax Act 2004, bracket O Act, bracket, for the period 26 September 2006, 31st March 2008. Full stop. While directing notice to issue in the present petition on 18 November 2016, this court stayed the impugned assessment order. Full stop. That interim order is continued since. Full stop. Paragraph: in the last over 6 years, no counter affidavit has been filed by the department. Paragraph: the background facts are that the petitioner dealer carries on business in textile fabrics on both wholesale and retail basis. Full stop. The petitioner effects purchases both from inside and outside the state of Odisha, but sells the goods only inside the state of Odisha. Paragraph: the AG audit team detected non-levy of tax for the aforementioned period on the goods sold by the dealer, and accordingly, on that basis, the assessment was finalized and demand raised under Section 43 of the OAT Act. Paragraph: the plea of the petitioner that in view of the additional duties of excise, bracket, goods of special importance, bracket, Act 1957, bracket, ADE Act, bracket, the goods would be exempt from sales tax was not accepted by the STO in view of the notification dated 1st March 2006 by virtue of which textiles stood exempted from the purview of the ADE Act. It was concluded that correspondingly, they would become amenable to sales tax from that date. Paragraph. However, the fact remains that the Government of India issued a clarificatory notification, clarificatory circular on 3rd May 2006, whereby it was made clear in para 2 that the aforementioned notification dated 1st March 2006, open quotation, does not change the earlier position in any manner whatsoever as far as the issue of VAT/sales tax on AED items by the states is concerned, unquote. So in other words, if prior to 1/3/2006, no sales tax was leviable on textiles by virtue of the AED Act, that position would continue, notwithstanding the exemption from the applicability of the AED Act extended to textiles. Full stop. The STO does not appear to have taken note of the above clarificatory circular issued by the Government of India. Full stop. Paragraph: in that view of the matter, The impugned assessment order dated 18 July 2016 is hereby quashed. The writ petition is allowed. No order is to pass.
Much obliged. Item 61.
May I please, my lord? My lord, I'm appearing through virtual mode.
Yes.
May I please, my lords? So PIL regarding.
We are not able to see you, sir.
Pardon, my lords. Apologize, my lords. But there's some trouble with the connectivity, my lords.
We'll pass it over, sir. You reconnect. Pass over.
Obliged, my lords. Obliged.
Item 62.
May I please, let's see. In this matter, my learned friend has to take instruction in this matter.
With regard to the differential GST amount,
the estimate was prepared when the OVAT Act was in force.
Yes. What I have received, I have already paid. And that is Annex 3, the payment receipt. Only my grievance is regarding interest and penalty. If the state government has paid me the bill in the belated stage, so who will bear the interest and penalty part? Whatever government has paid, I have paid to the government treasury.
If you want to file a reply, you file. You have to file a reply anyway, Mr. Mishra.
No grievance against the GST department, but I think no grievance against the GST department.
In the last occasion, I think my learned friend 6 times to take instruction. That is why in the first 11/2022, it was directed, and I have served a copy, extra copy.
Once is there, you should be working. I mean, appearing for the works department. Replies be filed both by opposite party number 2 and opposite party number 4. Within 8 weeks, we'll join them for the next date. The list on 8th May.
Item number 63.
Your Lordship, in this case, Your Lordship has issued notice. Your Lordship has also passed the interim order. Lordship, I may be prepared for 4 weeks' time to file counter reply.
Your Lordship, may kindly see the order dated 14/3/2022, passed by the other bench of this Honorable Court.
That's right. They permit you to operate the account.
Over and above the amount of demand which they claim to have been there, which has not been served on us, communicated to us. That is how Your Lordship said, all right, for the time being, we are allowing, permitting, but over and above the amount to operate. But in any case, I am prejudiced because that amount is stocked up.
That is 6,68,000.
Milers.
Mr. Mishra seeks and is granted further 4 weeks to file a reply as a last chance. Adjourned up for the next date. Interim order to continue. List on 5th April.
Item number 64.
Let's maybe submitting for Mr. Jena. And I am for the petitioner, and the opposite parties have raised an illegal demand by the Annex 3. So without giving any prior notice to me, at the same time, without following the due procedure established by a pattern of decisions by Honorable Supreme Court, and without giving an opportunity, directly they have raised a demand, notice illegal, which I have already paid for drawing less quota than what is fixed during the year 2008 to 2009, my lord.
This demand is appealable, I think.
Appealable.
Already I have complied, though I have complied, thereafter, even, my lord, kindly have a look.
You're still running this off shop or it's over?
I have already complied, my lord, since they have raised a demand notice.
Are you still running this off shop or it is all over?
No, must not.
I am running, my lords. I am running. Thereafter, they have also issued me license. Thereafter, if I have though violated their terms and conditions, but they have not issued or extended my license. But the license has been extended. I am running that shop, my lords.
Perhaps my lord.
My lord, kindly turn to page number 8, my lord. S7.
Your license is extended.
Yes, my lord. That was after 2011, my lord.
So we are in 2023 today.
Yes, my lord.
Today, you're still running this off shop?
No, today I have not that instruction.
The question, you're without understanding the question or simply saying yes to everything. My first question to you was, are you still running this off shop? You said yes.
My lord, I have not that instruction, but there are...
Then that is what you should have said, because the policy has changed.
Policy has changed. It is put to auction.
It's all old matters, sir. And
my lords,
most likely not running this off shop anymore.
My lords, I humbly submit that.
Yeah.
My lord, my humble submission is this before this honorable court, my lords. In 2009 to 11, because of short run of MGQ quota,
We are not merits.
Yes,
You all know the factual position today.
But that still, because of by virtue of stay of this honorable court, that demand is still pending on me, my lords.
Yes.
For,
Even if he has the licensee, he has every right to challenge the demand.
But thereafter, my lord, sir.
Yes,
my lord,
commissioner.
My lord, thereafter also, after demand notice is read in the year 2009 to 11, up to 2016, I have been running the shop. Again, if at all I have violated their terms and I have drawn less quota, this should not have extended as per the rules, my lord, rule 64. Here comes
you
rule
raise
35.
all these points before the appellate authority.
You say against the demand notice dated 9th February 2020,
under Annex 3, my lords,
which is challenged in this present petition. The petitioner has an efficacious remedy by way of a
appeal under Rule 252.
Or appeal before the Excise Commissioner under Rule 252 of the Odisha Excise Rules. 2017.
2007.
Permitting the petitioner to avail of such remedy, the court declines to interfere at this stage. If such appeal is filed not later than 16th February 2023, accompanied by an application for continuation of delay, citing the pendency of the present petition as the reason for the delay, be considered on its merits in accordance with law by the Commissioner, Excise Commissioner.
The interim order was passed on 18th
Till such
April
time, the
2000.
Excise Commissioner passes an order on the application of interim relief filed by the petitioner, along with the appeal within the stipulated time. The interim order passed with this court on 18th April 2016 will continue. The court clarifies it is not expressed any view in the matter.
My lord, my humble submission, if accepting that I do not succeed in appeal, my lords, then whatever the amount already I have paid, that government has not regularized it, and whatever I am ready to pay, but that amount will be excess in addition to whatever I have already paid, my lord, during the year 2011 to 2016.
Okay.
And
all right,
item 65.
Yes.
That's it.
My lords, item 65, I appear virtually, my lord.
Yes.
If your lordships permit, there was an audit objection in this matter, my lord, and that fructified in a demand. This company went insolvency, my lord. It underwent the CIRP process, and this demand was raised before the RP by the department, my lord. So that has been dealt with in terms of the resolution plan. There is another challenge to the virus of the provision, my lord. If
that may not survive now. If the demand itself doesn't survive, then the virus doesn't have to go on it.
If your lordships may only observe that if any cause of action survives, we may be permitted to withdraw with
in view of the subsequent developments, the present petition has been rendered infructuous, permitting the petitioner to file a fresh petition if any cause of action survives. The petition is disposed of.
Deeply obliged.
Item 66.
Lord, it's a pre-lottery
Infructuous, it is.
Infructuous now.
One just Lord, my apprehension, of course. Now that I do not have a license, my surrender application becomes irrelevant now, cannot be considered. Now the closure during this government land period, they may raise a demand.
Then more work for you, Mr. Rath. Good
Yes.
news. Good news.
I knew that he will make such submission, but that cannot be stopped.
That cause of action has not yet arisen.
Yes.
You say in view of the subsequent developments, the
Yes.
present petition has been rendered infructuous and is
Yes.
stopped as such. All right.
Item 67. 67.
None appears dismissed.
Item number 68.
68 and 69, both are audit objection.
Audit objection.
Well, correction it. Already correction.
Say what? All right. Made the corrections. All right.
Both matters. 68.
All right. All right.
Item number 70.
70. Item 70. This very petitioner company has been sold away. Some other entity has come in. So I am required to intimate them, the new company, if they would like to come before your lordship.
All right. At the request of Mr. Rath, list on first May.
None. Company died.
First May.
Yes.
Item 71.
71 not pressed, my lord.
Dismissed.
71 not pressed.
Not pressed.
Item number 72.
Lord, it's a question of shifting. The petitioner once was directed to shift the shop and he shifted it. Over the new location, now he is operating. At the behest of the rival traders, now collector is passing me an order giving 7 days notice to find out another location. Lord, first of all, collector has not the authority to pass this order. He should not pass this order without giving us an opportunity of hearing. I am a licensee generating revenue for the state. I am operating there by having shifted the shop. If Lordship sees that shifting order is available here, they allowed me to shift the shop. I shifted it. Page 137.
What's the response in the reply?
Lord, they said that the public have objected. There is absolutely no apprehension, no case registered. State is saying that some residents there objected. Lord, they should have objected at the Form 8 stage. At the stage when the notice was issued, they did not object. After I started operating, as the Lordship knows, at the behest of those rival traders again, some people have come and saying that shift it again. And collector is passing orders, Annexure 1. Lord, I say that collector Somoto could not have passed this order. Shifting is an issue. If under the rule, I'll have to apply for it.
So when you saw in so many other cases that you did not file objections in time, now you
No,
cannot
it
file.
is a case where when the shop was in operation, some people objected because it is Bhubaneswar. So many people objected that in our locality.
No.
And another thing, your lordship may kindly see para 5 of my counter affidavit.
No, even para 6.
The license was given a notice in Annexure 1 to find out a suitable on site.
That's right. Then he shifted. Then see para 6.
Yes.
After the shop is shifted to the present location from Rajmahal Square.
Now the petitioner is operating in the shifted location.
The same Jagamara. So at Jagamara, he's again being asked to shift from Jagamara.
Yes.
Because of that particular contingency.
No. When the proposal was made to shift it to Jagamara, there must have been a public notice, objections must have been invited.
But
that exercise is over.
Lordship may pass necessary orders. This is the position. These are going on in some cases. Due to some reasons, the authority is bound to take a decision.
Giving us bread and butter, Mr. Mahanti, should not stop it.
No. I don't. Because
you see the agreed by an order dated 29th April 2022. Asked for the collector giving 7 days notice to the petitioner to shift the location of the existing IMFL offshore operating at Jagamara. The licensee has approached this court with the present petition. Paragraph, while directing notice to issue in the petition on 10th May 2022. this code directed status quo to be maintained. The background facts are that the petitioner was initially operating the shop in ward number 53. And in fact, it was named as IMFL off shop Rajmahal number 2. Full stop. The petitioner got the license for the said shop on the basis of the lottery conducted by the state government in the year 2021-22. Stop. The initial location of the shop was at plot number 38 at Bapuji Nagar, Bhubaneswar. Stop. However, when the local residents objected to the operation of the shop, the petitioner applied for shifting of the shop, which was allowed. And on a Form 8 notice for shifting it to Jagmara was published by the collector on 23rd September 2021. There were certain objections filed which were inquired into by the Inspector of Excise, Bhubaneswar Range. And a report dated 22nd October 2021 was submitted to the Superintendent of Excise, Bhubaneswar. Stop. When the Collector Khurda rejected the application for shifting and passed the rejection order dated 5th November 2021, that was challenged by the petitioner by filing writ petition civil 36234 of 2021 in this court. Stop. The said writ petition was disposed of on 24th November 2021. Permitting the petitioner to appeal against the said order to the Excise Commissioner. Full stop. Paragraph. Thereafter, the Excise Commissioner referred the matter to the government, which in turn permitted the shifting of the shop by an order dated 31st March 2022. On that basis, license was issued in favor of the petitioner on 1st April 2022 in respect of the new location of the said IMFL off shop at Jagmara. Paragraph. According to the petitioner, at the instance of certain rival traders, objections were again filed by some private persons after the petitioner started operating the shop at Jagmara. Without notice to the petitioner, the Collector Khurda passed the impugned order giving 7 days time to the petitioner to shift the shop again. Paragraph. In the reply filed to the present petition, the above facts are not disputed by the respondent, by the opposite parties. Full stop.
My lord, may kindly record my objections.
Yes. It is noted in para 6 that after the shop shifted to Jagmara from Rajmahal Square, the local people objected. As a result, the Collector Khurda, exercising powers under Rule 31 of the Odisha Excise Rules, directed the petitioner to find yet another suitable location to shift her shop. Full stop. paragraph. With the petitioner already having shifted the location once, which was preceded by a public notice in Form 8 and objections being filed and considered, there was no occasion for the Collector Khurda to require the petitioner, after the shop was shifted to Jagmara, to again require the petitioner to shift the location. Full stop. This too has been done without observing the principles of natural justice by putting the petitioner on notice regarding the objections received about the location of the shop. Full stop. Therefore, on both counts, it appears that the impugned notice issued to the petitioner is unsustainable in law. Full stop. What is Rule 31 of P? How is this? Is Rule 31 applicable?
It's not applicable.
A reference has been made in the reply to Rule 31 of the Excise Rules 2017, which does not appear to be applicable in the facts of the case. There is no power in the collector.
No. It is with the approval of the commissioner, he can pass the final order.
It is only a reference. It is only a reference.
To have power to require a shop to be shifted. It is only the commissioner, excise commissioner, who has to permit the shifting of a location of the shop after following the due process as outlined under the OE rules. Paragraph. For all of the aforementioned reasons, the court finds the impugned notice issued to the petitioner to be unsustainable in law, and it is hereby set aside. The petition is allowed. No orders to cause.
Great one.
Item 73.
Lordship, after loss.
Why? It's a long matter.
It will take 10 minutes.
Okay, we can pass it over.
Or pass it.
Okay. 74.
74, my lords. I have been informed by my learned friend on the other side that his father has expired on 1st of January.
Or counsel for the respondent stated been some personal difficulty today. List on 2nd May.
2nd
May.
Item 75.
My lord, I am for the opposite party. Senior counsel Mr. Patnaik is ill. My lord, he is in maybe taken any other day.
No, who's for the appellant?
My lord, I am appearing for the
counsel for the senior counsel Mr. Patnaik appearing for the opposite party respondent is stated to be unwell. List on 8th May.
Public. Item 76.
Interim order to continue. Interim order to continue.
74 interim order is to continue.
Yes.
76.
May I please, Your Lordship? Your Lordship, kindly see earlier order dated 24/11/2020. Did my Lordship get it? 24/11/2020. The matter is taken up through video conferencing. Mr. Samant Rai, learned additional government advocate, shall obtain instruction from respondent number 1 in view of the letter Annexure G/2 issued to the appellant from the Odisha Lift Irrigation on 19th January 2017 regarding extension of rehabilitation assistance scheme to government employee by the next date. Put up this matter on 3rd December. Thereafter, Your Lordship, order number 14/12/2020, as prayed by the learned additional government advocate, put up this case on 11th January 2021. That instruction has not been obtained or that counter has not been filed. That is, Your Lordship, Annexure G/2 is a letter written from the Director Lift Irrigation to the government about my appointment. That is, your lordship will find that annexure G by 2, page 80. Your lordship will see.
What are the instructions?
Sir, I've received the instructions. I'll just file it in the form of an affidavit.
All right. Mr. Mohanty states that he will file an affidavit incorporating the instructions received within 2 weeks. Rejoinder that, if any, before the next date. 2nd May.
2nd May, your lordship. Rehabilitation matter.
77. Item number 77.
Please, your lordship. Well, I have challenged the order. The board has challenged the order of the Honorable Single Judge Mehra. This is a case regarding payment of financial benefit, my lord, from out of the fund of the marketing committees. But the Honorable Single Judge said that the state or the board has no power. Only the committee has the power. But there was a direction by the government, my lord, that if any financial benefit is to be given, then it should be given, my lord, from out of the fund of the from the respective committees.
Who's appealing for the
My lords.
Officer
please,
party number 1?
Yes, your respondent number 1, your lords. Your lordship, just I'll point out one more thing, that the irony being that relying upon my judgment, this parent judgment of 26/3/2019, 2 other RMCs have already been granted benefit. They are availing their benefits. Then why were we restricted? We are being restricted.
Where are those details?
If your lordship sees the next writ appeal number 151 of 2020, annexure A1 series. I will also pass on your lordship.
No counter copy is given.
Your lordship, I am just passing on to memos, your lordship, in both the cases where I have highlighted that 2 RMCs, RMC Mukhigoda and RMC Sakigopal, have already been granted benefits under 6th Pay Commission, relying upon my judgment. That apart, your lordship may kindly, if your lordship gives me some time, I'll walk you through the statute, your lordship, what the statute says. The statute clearly says...
Anyway, you're just now filing this memo, right?
Indeed, your lordship.
You have to sign it, sir. Nothing, it's all blank. It's all blank. You have not signed it also.
Sorry, your lordship. I beg your apology then, your lordship. I beg your apology.
Copy of the memo filed by the counsel for respondent 1 has been handed over to counsel for the appellant who needs time for instructions. List on 10th May.
77 and 70.
Both the matters.
After lunch. Right.
DG who is supposed to appear, Mr. Chabra, he will be going to Delhi in the second hour. So may I request that a noting may be given in the list that it will be taken up at 10:30 or 10:30 at night, so that everybody will remain present in virtual, so including the additional chief secretary. 10:30.
Supplementary list item 79.
79.
Item number 79.
No, please.
Sujan Shukla. Okay. Sorry.
Item number 80.
May I please,
This is again first
similar to item 31.
So same, despite service of notice and appeals, and then same order. Item 41.
Item 42.
Same date, I think. Indicated date there.
81 also same.
81 also same. All right.
81, my lord, I am for respondent number 1.
So it will go back.
Fine. Password. Supplementary list password matter item number 26.
Yes, sir. So far as defects are concerned, my lords, the IA pertains to my lords prayer for dispensing with certified copy, because the original orders I have given before the statute of appellate authority. And regarding other defect number 9, lords, prayer it is mentioned that that's a formatted application, so that may be ignored. Your lordship always ignore.
Correct.
And other one, 10 of the defect subject code. Now I have complied with, my lords.
Right.
Now today, so far as these are STRE, Millers, because I have today I have submitted one modified questions, Millers, reformulated questions. So Lordship may kindly admit them the reformulated questions, Millers. If your Lordship permit me, I will place it, Millers.
Right. So the reassessment without reason.
My lords.
All right. You say admit the following questions.
Your lordship, prima facie on the face of the orders, your lordship, the first appellate authority has remanded the matter for phrase assessment, your lordship. By clarifying all these questions of law, he has admitted that there is mistake apparent on the face of record. Thereby, the first appellate authority has set aside the matter for phrase assessment as per law, your lordship. And that order, the first appellate authority has been confirmed by the learning tribunal, your lordship. Against that, this revision petition has been filed. Your lordship may kindly turn to page 38, the first appellate authority's finding. Your lordship, the first appellate authority's finding is that based on perusal of the assessment record, it is noticed that the assessing officer has issued notice in form BAT 307 of the dealer appellant for the assessment on escape turnover so-and-so for the period, but completed assessment 42 for the above period is contradictory. Further, in perusal of the order sheet maintained by the assessing officer, it is noticed that the AO has not recorded any reason for initiation of the proceeding for reassessment either in order sheet or in the notice BAT 307. The AO is simply accepted.
So after all this, why send it back then?
Exactly. That is my question. I have
you can improve the record.
Your lordship,
by sending it back, this record will not.
That aspect, how your lordship?
That's one of the questions. Because one minute, my lords may kindly turn to page 44. That will give answer to everything, my lords. My lords, the first authority has accepted the contention of the petitioner in this case and has deliberated and allowed in my favor. And instead of allowing the appeal, he has
sent it back. It's not have sent it back.
And your lordship,
how can he send it back? Indure fully covers that.
Your lordship, obviously covered. But so far as the assessing officer is concerned, your lordship, also that part, this matter has been restored on both the issues. The matter has been restored.
My lords. Indure and your lordship order also I have given. My lords have also dealt in that aspect.
Framed for consideration. Whether the assessment under section 43 of the Odisha Value Added Tax Act 2004 (OVAT Act) requires to be set aside, considering that, in light of the judgment of this court in Indure Limited versus Commission of Sales Tax, Cuttack, Orissa, 2006, 148 STC, 61 (Orissa). Question mark.
Paragraph 39 to 42.
Right. The present revision petition arises from an order dated 26 February 2021, passed by the Orissa Sales Tax Tribunal, Cuttack, in dismissing the dealer's SA number 122-5 of 2019 for the period 1st April 2012 to 31st March 2014. Paragraph. In effect, the tribunal affirmed an order dated 29th April 2019, passed by the Joint Commissioner of Sales Tax, Appeal, Cuttack, JCST.
Annex 7, my lords may kindly refer to order says no reason. That is what the genesis
Yes,
is.
yes.
Page 46. Yes.
Setting aside
page 46.
Assessment order passed by the Additional Sales Tax Officer, Kendrapada Circle, Kendrapada, under Section 42 of the OAT Act. Paragraph. The dealer is engaged in the manufacturing of groundnut oil and de-oil cake using raw groundnuts. Full stop. The original assessment was completed under Section 42(4) of the OAT Act for the aforementioned period, raising a demand of Rs 2120 towards tax and penalty. Full stop. The assessing officer did not calculate any VAT on sale of de-oil cake because it was exempt from VAT. Paragraph. On the basis of the report of the AG audit on short levy of purchase tax, the Additional Sales Tax Officer initiated proceedings in Form VAT 307 and thereafter proceeded to complete the assessment. Raising a demand and penalty totaling Rs 235,352. Full stop. The appeal filed by the dealer against the above assessment order came to be allowed by the JCST by the order dated 29th April 2019. Full stop. The JCST noted in the order as under. Just take from page 44, there's an extracted portion. Paragraph. However, instead of quashing the reassessment order, the JCST chose to remit the matter to the AO for a fresh proceedings, for a fresh hearing and a decision. Full stop. It is this order that has been affirmed in the further appeal filed by the dealer in the tribunal. Paragraph. This court has heard the submissions of Mr. Jagabandhu Saul and a senior counsel for the petitioner, Sunil Mishra, and additional government standing counsel for the department. Paragraph. The factual finding by the JCST was that the reopening of the assessment was done by the AO by simply accepting the objection of the AG audit without forming independent opinion on whether such objection by the AG audit was correct or not. Full stop. There was no recording by the additional STO about being satisfied independently that there was escapement of taxable turnover. Full stop. The legal position in this regard has been explained by this court in Indure Limited versus Commission of Sales Tax.
For a 39 to 42 minus.
Recently or not?
Yeah, that's also there.
I have also given.
Yeah. Where it has been held that an objective opinion has to be formed by the STO, and that he cannot, open quotation, totally abdicate or surrender his discretion to the objection of the audit party by mechanically reopening assessment under section 12 bracket A, as has been done in this case, unquote. Stop. It may be noticed here that the above observation was made in the context of section 12 bracket 8 of the Orissa Sales Tax Act 1947, which corresponds to section 43 of the OVAT Act. Paragraph. The above settled legal position has been reiterated by this court in its order dated 22nd March 2021 in writ petition civil 3821 of 2013, bracket, Messrs. Goel Traders versus Sales Tax Officer, bracket, paragraph. In the above circumstances, simply remanding the matter to the STO, as has been done by the JCST, would serve no purpose, since it in no way would it alter the factual position, namely that in the record sheet, there would be no recording of the objective opinion of the STO about escapement of taxable turnover. Paragraph. In that view of the matter, while setting aside the order of the tribunal, as well as the JCST and the corresponding order of assessment order, this court disposes of the revision petition by answering the question framed in the negative, that is in favor of the dealer and against the department.
I thought I have argued on behalf of the government, but when you more argue, then you will face more problem.
All right.
My lord, I may kindly be excused. Item number 79 supplementary. Was it passed over or Arjun?
That you'll have to find out from him, sir. Yes.
Item number 61. Passed over matter item 61.
My lord, in 61. May I please, my lords? May I please, my lords?
Yes.
I'm appearing through virtual, my lords.
Yes.
No, it's a PIL regarding garbage dumping, unauthorized construction and obstructions of public roads, my lords. The last occasion, my lords had directed to file photographs.
Yes.
The petitioner had filed 4 number of photographs, my lords. Yesterday only he has filed the photographs.
Where is that? Where is it, sir?
I have the receipt, my lords. I filed it in the filing count.
Let's just see. One. It's not been brought on record, he says.
I shall file it. I shall be filing it again, my lords.
All right. Counsel for the
My lords,
in
the meantime, I'm appearing for BMC, my lords. In the meantime, I had also asked my officers to do a survey of that area. So they have got the photographs relevant, and it said that moja is not being used for solid waste.
Okay.
That's my specific submission. I filed an affidavit to that effect.
Okay.
I couldn't serve a copy on the petitioner because I couldn't find him in the court today.
All right.
And also, I've got a pen drive for the video. It's with Short. the court officer. Short adjournment may be given, my lords, that to enable the petitioner to file additional affidavit as well as some more photographs.
No, just let's play the video. You can watch the video, sir. This is the latest video submitted by the corporation.
My lords, the petitioner is a senior citizen, my lords. He's 78 years old. So he has given me photographs yesterday. The problem of dumping has escalated to a level, my lords. Now they're dumping just next to the runway, my lords. The airport
Kindly watch
runway.
the video, sir. Kindly watch the video.
May I submit, my lords?
This is that plot 9 and 9A.
9 and 9.
I see.
Because there are still 2 roads that have still being obstructed. And the opposite party number 2 has closed a 60-feet wide road. It's still closed, my lord. Let a short adjournment may be given so that we will also file.
We'll certainly do all that, sir, but don't interrupt when you are still watching the video, which means you're not prepared to even watch what is being shown. It's the same thing. All right. All right. It's an affidavit has been filed by the Deputy Commissioner Sanitation, Bhubaneswar Municipal Corporation, dated 11th October 2022, stating inter alia that the land in plot number 9 and 9/A, Ananti Vihar, Moza, Pokari Port, is not at present being used as a temporary transit point or as a dumping ground for solid waste. Stop. Certain photographs have been enclosed. Stop. The court has also been shown a videograph in a pen drive, which was submitted in a pen drive and which was played in the court in the presence of counsel to the petitioner, who appeared online. Paragraph. Ms. Padi, learned counsel appearing for the BMC, states that another survey will be undertaken of the area and including what is the road, sir? Which road are you talking of?
The 60-feet wide road, my lords.
Including a 60-feet wide road. Does it have a road number or name?
It is located at southern side of plot number 9A, my lords.
Okay, on the southern side of plot 9/A, to ensure that the said road is not being blocked by the dumping of waste. Stop. The survey report will be placed on record with an affidavit on the next day. Paragraph. Counsel the petitioner also volunteers to place photographs of the current situation by the next day.
May I submit, my lords?
Yes.
My lords, the illegal dumping was on the 25-feet wide road and the and another sub road located at the western side of plot number 9.
Okay, including that 60-foot fort road and the 25-feet road on the western side.
The latest development is that the 25-foot wide road, they are not dumping on it, my lords, at this point of time. But the 60-feet wide road, that is located at the southern side of plot number 9A, that has been illegally obstructed. Man. There are some illegal constructions that have been made.
So that's a different issue altogether. I think we're now mixing up all kinds of things.
No, my lord,
you've started off in this petition about dumping of solid waste, correct?
My lords.
Now you're going on to some encroachment, illegal construction. That's a different issue.
My lords, may kindly see page number 9, my lords. I've mentioned this in the public interest litigation also.
No. So you're now not any more concerned about dumping of solid waste?
No, my lord, dumping is continuing, my lords. Dumping.
Where is it continuing, sir? Tell us the location where it is continuing. We'll ask them to survey that.
On the just next to the airport runway, my lords. There is a wall just next to the runway on the Pokariput square itself.
You mentioned plot 9 and 9A, which is why we issued these directions.
My lords.
Now you're talking of some other area now.
It is 300 to 400 meters away from the plot numbers I have mentioned in the annexure 1, my lords.
So you can't go on expanding the petition. Then next you'll know that we'll be looking all over Bhubaneswar now. There has to be some finiteness to this whole exercise, sir.
No, small adjournment may be given so that I will also take instructions regarding.
No, for what? We have to. This is. We have to be serious about what we are wanting.
My lord, I've mentioned all these things in the public interest litigation. My humble submission is that the 60 feet wide road, as I've mentioned in the petition, opposite party number 2 have obstructed it. And they have.
Sir, is it obstructed by dumping of solid waste, or is it obstructed by illegal construction? Let's be clear.
Illegal construction, my lord.
So that is not what the obstruction we are talking about.
My lords.
That part is over then. So you yourself admit that it is all stopped now, the dumping of waste.
Small adjournment may be given so that.
Sir, we can't go on this whole. We are not listing. When 2 judges are not sitting, we are not spending all this time only for adjournments. Let's be clear on this.
I may be pardoned, my lord.
Let's be serious. Let's be serious because this is a public interest litigation. Let's be serious about what we want. We don't have that luxury of time that we go on adjourning matters.
My lord, only a small adjournment may be given. I'm praying only because I filed photographs yesterday itself. I have the acknowledged slip with me, my lords. I filed the photographs yesterday itself. Only 2 weeks time.
No, photographs of what? You tell us photographs of what did you file?
I filed the 4 number of photographs, my lord.
Of which plot, sir? Of which area?
Of plot number 9 of the roads, my lord. Of the roads that have been obstructed. The 60 feet wide road and the...
Sir, the photographs, if they're going to show solid waste being dumped, we can understand. What do the photographs show?
My lord, 2 photographs are of the obstruction of the roads, my lords.
Obstruction by illegal construction, according to you.
My lords, my lords.
So that we're saying that we're not examining that here. Yes. Then?
And 2 other photographs of there of dumping of illegal solid waste.
Where?
Of solid waste.
Where?
Just next to the airport runway, man.
That was not your original petition. Your original petition was not about next to the airport.
My lords, the plot number 9 and 9A are also very close to the airport runway, my lords. If your honor will kindly, if your lordship will kindly see the petition itself, I have mentioned all these facts in the petition itself.
Okay, I think you survey also whatever next to the airport. You just say, then take off the whole thing. If you undertakes to have a survey conducted of some plots supposed to be adjacent to the airport, where according to the petitioner, solid waste is being dumped. The survey report be filed with an affidavit before the next date.
Because, my lords, it will create
List on
menace.
8th May.
Highly obliged.
Pastor matter item number 73.
My lord, I may kindly be excused once again. 79 item, actually, my junior...
Sir, we are in the midst of something, sir.
My lord, that...
Kindly excuse us, sir. When we are in the midst of a list, don't interrupt us. Thank you, sir. Thank you so much. Thank you very much. Don't interrupt, sir. Kindly wait for all the matters to be over. Then we will hear you. Thank you. Thank you.
Item 73.
On behalf of Mr. J.K. Mahanti, I am permitted to place, my lord.
Yes.
Here, my lord. The order passed under Annexure 2, dated 16/1/2020 is under challenge, my lord.
Yes.
Sole question here is to be decided, my lord, whether the list finance purchaser are a necessary party to the proceeding or not. Before going to that, my lord, the lordship, I have to prepare a date chart, but I have not prepared, but I am submitting, my lord. What is the fact, my lord? The present respondent number 5 and 6, my lord. They were the recorded tenants in the Hall settlement as well as consolidation operation, my lord. Accordingly, they sold the land to me. In the 2012 and 13, I have purchased the suitable property under 2 sell deeds, my lords. I was a bona fide purchaser. I am not aware that the, sorry, my lord, 5 and 6 were the purchase recorded tenants in the Sabiq settlement, but in the Hall and consolidation, the ancestor of 7 to, respondent of 7 to 23 were recorded tenants. And from them I have purchased. But I was not aware that the present respondent of 5 and 6 had initiated a revision case before consolidation authorities, my lord, the respondent number 1, my lord. The said case was filed in the year 2008, my lord. When thereafter, the present respondent number 5 to 6 approached the honorable court for early disposal of the revision case before the consolidation commissioner. At that time, they added me as a party. Earlier, I was not a party before the consolidation commissioner. The said case was disposed of, my lord, on PC number 9000-2012, that was disposed of on 27/1/2016. Thereafter, I went to the consolidation officer, commissioner, I filed an application under Order 1 Rule 10 that I am a necessary party because before Honorable High Court, I was already as party. The consolidation commissioner disposed of the revision petition without whispering a single word about my Order 1 Rule 10 application. Challenging the same, I approached this Honorable Court. That is WPC number, the order which is under challenge, my lord, WPC number.
So come to para 10.
14,984.
Kindly come to para 10 of the impugned order.
My lord.
Page 71.
My lord. It further appears that the petitioner after purchased the case land and had never applied to the company authority to correct the prepare the ROR in its name. Here my respectful submission before my lords. I have purchased the land in year 2012 and 13. The writ petition before the Honorable Court was filed in the 2012. I was noticed. When the case is pending before the commissioner, I came to know. So there is no occasion to approach the mutation, my lord.
Why? Once you purchase a land, why do you have to wait for anything
else? I am going there, my lord. 41 after 41 notification, the present respondent 5 and 6 applied for revision after 28 years. I have given 4 judgment, my lord.
1 minute, sir.
Yes, ma'am.
Come to the judgments in a minute. Kindly don't jump. Let's understand the facts.
My lord.
Why did you not apply for ROR to get your name entered?
My lord.
Why did you not get your name entered in the ROR?
My lord, in 2 cell deeds, 2012 and 13. I have applied. Yeah, I have purchased. 2012, I received notice from Honorable High Court, which was filed by respondent 5 and 6. And from that writ petition, I came to know that a revision application is pending for consolidation authority under section 37(1). So it is when 37(1) application is pending there, mutation case is not maintainable. That's why I waited until disposal of the writ petition before this Honorable Court. When writ petition was disposed of before this Honorable Court, I approached the commissioner. 37(1) in 37(1) application, I filed one application on Order 1 Rule 10. Sir, I am a bona fide purchaser. I should be heard. London Commission didn't whisper a single word. And the judgment was passed. ROR was corrected. And thereafter, I approached this Honorable Court. When I approached this Honorable Court, the Honorable Single Judge has, your lordship, next, before that, page 70, Your Honor. Paragraph 9. Taking into consideration the rival contents of the parties and on perusal of the record, it appears that the petitioner had purchased the case land by registration so and so when the consolidation revision case was pending before the commissioner. I am a bona fide purchaser, I do not aware. When I noticed, I appeared. Until the disposal of the writ petition, there was no occasion to appear before the commissioner, my lord. Now, Your Honor, my lord's sole question is to be decided whether, in view of section 52 of Transfer of Property Act, whether I have a right or not. The respondent number 7 to 25, they sold the land. They are not contesting. Now I am the best person who will fight for safeguard of my property, my lord. I am bringing to my lord's kind notice. I have given, that is one Amit Kumar Shah, my lord. I have given that judgment, my lord.
Whose were the
my lord, the case is not so easy, my lord. My lord, this is a small matter, my lord. My lord, the fact is like this, my lord. My lord, this is on the British property, my lord. And in 1913 also, the property has been recorded in the British name, my lord. That is opposite party number 5 and 6. My lord, on suddenly, my lord, in the year 1962, the ROR without any authority, that it was recorded in the name of one Lal Mohan Patnaik and others, my lord. My lord, thereafter, my lord, in the settlement ROR, my lord, in 1962 and consolidation ROR.
Whom are you appearing for?
My lord, for the state, my lord, one point, my lord, when in 2008.
Whom are you appearing for?
My lord, for 5 and 6, my lord. Like Paduka Ashram.
Mm-hmm.
I am for Paduka Ashram, my lord.
Mm-hmm.
The deed is property, my lord. Mm-hmm. My lord, kindly see this order, my lord. There is a stay of the alienation. This is the order, my lord. In 2008 by the revisional court. And our vendors were made parties in that revision, my lord. when our vendors were made parties, the consultation revision was going on. Suddenly, they said that in 2013, they purchased that property from one of the party in the revision petition, my lord. And they want to be included as party on the basis that their vendors are not conducting the case properly. So we will be included as parties. Whatever that may be, they are the lease pendency purchaser, my lord. That comes that hit by section 52 of the TP Act, my lord. The Lord and single judge, my lord, kindly see that order, my lord. That is stay of the sale and anything, my lord.
It's all right.
My lord, that order prevails, my lord.
Yes.
In the meantime, that they purchased the land, they said that they purchased that land, my lord.
By registered sale deed.
By registered sale deed from the vendor. My lord, when there is a stay of the...
How will they know? They didn't know all the stay.
My lord?
Nobody was aware of the stay.
No, my lord. Our vendors are there. My lord, whatever that may be, my lord.
Madam, these are bona fide purchasers who are unaware of the stay.
No, my lord, this is the point, my lord. Whatever is that, the single judge has said that they have the already other forum, my lord. They have filed the suit,
forum?
my lord.
Which other forum?
They can file one suit, my lord.
Why multiply litigation?
My lord?
Why multiply litigation?
My lord, this Supreme Court, my lord, has already, in their judgment, my lord, said that it is the plaintiff who will be, his discretion is that to add the parties, my lord. My lord, in this case, my lord, kindly see. My lord, kindly see, my lord. Kindly see what Lord and single judge has said, my lord. It is, however, open for the petitioner to seek the appropriate remedy, my lord. In this, my lord, the Lord and single judge has already said that they are the lease pendency purchasers, my lord.
Correct. Why should they not be made parties in the litigation case? That's the only question.
My lord, when their vendors...
They are both necessary.
No, my lord, when their vendors' title is in dispute. My lord, their vendors' title is in dispute. And also the Lord and trial court said that they have no...
So you agree that their vendors were party to the revision petition?
My lord.
So why can't they, for bona fide purchases from the vendors?
No, my lord, when the sale has already been stayed, my lord,
that's a different issue, madam. We're only on this revision case, whether they are necessary and proper parties. We're not deciding, nobody's deciding the title of this.
My lord, kindly see, my lord. My lord, the trial court has strictly, my lord, the trial court said that the settlement ROR in 1962 consultation ROR wrongly recorded their names, my lord. And also, my lord, kindly see their his decision, my lord. Their vendor's name has wrongly recorded as tenants in the consultation ROR, my lord. In the read petition, they have admitted, my lord. In the read petition, they have admitted.
All right. All right. Anything else?
My lord, when they have admitted that there is that the vendor's name are there wrongly recorded, and we are the owners of the property, then all these things will not apply, my lord. My lord, when there is a status quo order. And also, when their vendor, this is between their vendor and themselves, my lord. When the court has already stayed the proceeding of sale and all those things. At that time, sale is void one, my lord. So these they are not the bona fide purchasers or anything else, my lord. Their sale deed has to be gone.
All right.
My lord, kindly see the last portion of the order, my lord.
All right. The challenge in the present writ appeal is to an order dated 16 January 2020, passed by the learned single judge, dismissing with petition 4984 of 2017 filed by the appellants. Paragraph in the said writ petition. A challenge has been laid to an order dated 27 January 2017, passed by the Commissioner, Consolidation and Settlement, Bhubaneswar, and Consolidation Revision Case number 37 of 2008, under Section 37, bracket 1 of the OCH and PFL Act 1972, bracket Act. Whereby the said revision case filed by opposite parties 5 and 6 for correction of the record of right, bracket ROR, prepared in the name of the vendors of the petitioners, that is opposite parties 1 to 10, was allowed. Full stop. Paragraph. As far as the present petitioners are concerned, they claim to have purchased the property in question under a registered sale deed from the vendors of the opposite parties 5 and 6 during the pendency of the aforementioned revision case 37 of 2008. In effect, the present appellants were list pendants purchasers. Paragraph. The learned single judge has observed that although the petitioners, the appellants had purchased the case land by virtue of registered sale deed dated 4th February 2013, during the pendency of the consolidation revision case 37 of 2008, they could not seek to be included in consolidation revision case number 37 of 2008 only because they did not apply to the competent authority to have their name in the ROR, mutated in the ROR. Full stop. Paragraph. Counsel for the petitioner points out that the appellants could not have applied for correction of the ROR as long as the revision case was pending before the commissioner. Full stop. Counsel for the respondents 5 and 6 that is the petitioners in the consolidation revision case, argued that the remedy of the present appellants would be to file independent suit for recognition of their rights, if any, under the registered sale deed. To stop, according to her, the sale itself was null and void in view of an interim order passed by the commissioner in the consolidation revision case, restraining alienation of the land in question. Paragraph. It is not in dispute that present appellants were unaware of the aforementioned interim order passed by the commissioner in the consolidation revision case 37 of 2008. Full stop. They had purchased the land in question under a registered sale deed during the pendency of the revision case. Full stop. The question at this stage is not whether such sale in favor of the present appellant was valid or not, but only whether they are, by virtue of such registered sale deed, a necessary and proper party to the revision case before the commissioner. Full stop. There can be no doubt that with the appellants claiming to have stepped into the shoes of their vendors, who were parties to the revision case, they were both necessary and proper parties to the said revision case. Full stop. In other words, the revision case could not have proceeded without including them as parties. Stop. This did not depend on whether the appellants had their names entered in the ROR, which in any event would not be legally feasible as long as the revision case was pending. Paragraph. For the aforementioned reasons, the court is of the view that the alleged single judge was in error in dismissing the writ petition filed by the present petitioners, assailing the order passed by the Commissioner, Consolidation and Settlement on 27 January 2017 in Consolidation Division case number 37 of 2008. Stop. This court accordingly sets aside both the order dated 16 January 2020 of the alleged single judge in the petition civil 14984 of 2017, as well as the order dated 27 January 2017 passed by the Commissioner Consolidation Settlement in Consolidation Division case number 37 of 2008. Stop. As a result, Consolidation Division case number 37 of 2008 and restored to the file of the Commissioner Consolidation Settlement, and is further directed that the present appellants will stand impleaded as opposite parties in the said Consolidation Division case number 37 of 2008. Full stop. It will now be listed. The said case will now be listed before the Commissioner Consolidation Settlement on 27th February 2023, on which date the present appellants and respondents 5 and 6 will appear through counsel. Stop. The Commissioner is directed to proceed afresh, proceed to decide the said Consolidation Division case afresh with a reasoned order, preferably within a period of 6 months thereafter. Till such time, status quo shall be maintained by the parties. The writ appeal is accordingly allowed. No resistance. We reached.
Millard, I suppose the list is exhausted. Your Lordship, give me liberty to make a sir.
Yes.
Actually, before the launch, prior to launch, my junior was present. Under confusion, she could not make a mention. So for non-appears, the WA has been.
Tell us what is it now. Tell us what is the item 79. Proceed. Tell us.
That is WA 155.
Tell us.
Item 79.
79. My lord, in this case, the WA has been filed seeking, in fact, the modification of the order passed by the Honorable Single Judge in WPC. In WPC number 3346 by 2020. The short facts is that the appellants were in possession of a certain pieces of lands under Khata number 27 in Mouja, Kalapuri in Berhampur town. And time to time there are encroachment proceedings against them. And in those encroachment proceedings, they apply to settle that land in their favor. That is since 1995. Thereafter, the Lieutenant Tahsildar Berhampur dismissed their petitions, against which they preferred appeal before the sub-collector Berhampur, who remanded the matter. And the Learned sub-collector Berhampur, by Annexure 1 in the read petition, again he remanded the matter to the Tahsildar for fresh adjudication, giving an opportunity of hearing and making an roving inquiry regarding their possession, and also to ascertain as to whether they are landless persons. And when all these matters were pending before the Learned Tahsildar, he again threatened to, in fact, passed orders for their eviction, against which they preferred appeal. They preferred a read petition before this Honorable Court. And this Honorable Court, by Annexure 2, again passed an order directing the Tahsildar to dispose of those LE cases before him. And the Tahsildar, since then, is not passing any order, sitting over the matter, and otherwise also threatening them for eviction. Two persons, namely Subhas Behera and Durjodhana Gowda, by Annexure 6, they preferred another read petition, but this Honorable Court was pleased to dispose of that read petition in view of the earlier order passed by the Honorable Court. Then on 26/11/2018, in another read petition, that is by Annexure 6, page number 46 to 48, the matter was again disposed of, that this is not maintainable and you seek otherwise remedy. And ultimately, the impugned order was passed because another read petition, the read petition was filed because they started fresh proceedings under Public Premises Eviction Act, Odisha Public Premises of the Occupancy Act. And the Honorable Single Judge was pleased to pass the order directing for disposal of those OPP cases. My only point is that when the encroachment proceedings, when the LE cases were pending and the Tahsildar is not passing any order, the fresh proceedings under OPP Act is not maintainable. For that reason, we have
been sent back for a fresh hearing. The impugned order only sends it back for a fresh hearing. That's all. It's not prejudicial to you at all. You've in fact succeeded in the writ petition, sir.
My lord,
the writ petition, you have actually succeeded. The impugned order, the order that you challenged in the writ petition has been set aside and the matters have been sent back.
Then I may be permitted to agitate the matter before the Learned Sub-Collector.
That's all this there.
On this point, regarding the maintainability.
The directions contained in the impugned order to be adverse to the petitioner at all. In fact, the writ petition has been allowed. Writ petition has been disposed of by setting aside the order under challenge and directing fresh hearing by the authority in the OPP cases. Consequently, the court is not inclined to interfere in the appeal, which is dismissed as such.
Both the LE cases and the OPP cases.
Weekly list. Item number 70, WPC number 12426 of 2014.
None appears for the petition. Dismissed.
Weekly list item number 71.
71, my lord, no instructions.
No instructions. Dismissed.
Item number 72.
Item number 72, I am appearing on behalf of the opposite party.
Use the mic, sir.
I am for the petitioner, my lord.
Tell us. Tell us, please.
My lord, you have filed the writ petition challenging the notice dated 19/4/2014 under Annexure 2 and in reply rejecting the letter dated 10/5/2014 under Annexure 4, my lord. My lord, the petitioner has availedly loan term loan of 6 lakhs rupees on 27/11/2008, my lord. And after availing such subsequent payment, my lord, the It was created on equitable mortgage of the land and building recorded in name of one Sheikh Abdul Rahim, my lord. And after availing such loan, substantial payment was made until 18/3/2014. That in the meantime, the opposite party bank, my lord, adjusted the fixed deposit provided by the petitioner at the time of availing the loan. And all of a sudden, the opposite party issued the notice under 13(2) notice of the SARFAESI Act on 19/2014.
What happened in the SARFAESI Act proceedings, sir?
Mr. Jana, what is the outcome of SARFAESI proceeding?
Well, he challenged notice under section 13(2) and 13(4) here. My information is it is not maintainable. And
have you understood the question? Have you understood the question that was asked?
The question?
Now, what is the outcome of that proceedings?
13(2) till today they have not put the property to auction.
So you pursue the remedy there, sir.
Because of the order, the interim order of the honorable court.
The petitioners approached this court at a stage when proceedings are still pending before the Debt Recovery Tribunal under the SARFAESI Act. Consequently, the court is not inclined to interfere, permitting the petitioner to pursue its remedies in the aforementioned proceedings in the DRT. The court vacates the interim order and disposes of the petition.
That maybe it's one number 38 was also passed over. 38. Item 38, Bhagat.
All right. Yes, let's take it up. All right. 38.
No, wait.
Yes, please.
Your Lordship may take up WPC 4728 of 2014.
38 is what? Of the weekly list?
Of the weekly list.
Well. Yes.
4728 of 2014.
Padmavati Nayak.
Yes, Maharaj. Your Lordship, there is an affidavit which I filed on 10th of October 2022. Lordship may take that affidavit. Well, there were two brothers, Ullasa and Hulasa. These two brothers were granted lease under the government lands of government land in WLL case, contiguous lands. Now, both the leases came to be cancelled by exercise of powers under Section 783. Both had challenged it. Now, as far as Hulasas is concerned, that matter in the meantime has been set aside by the ADM. Now, the other brothers, he's dead, his wife is there. The same order can be passed. So I have enclosed the order to this affidavit, that is at Annexure 6, page 6.
So the matter can go back to the ADM?
Yes, ma'am.
All right. Yes, Mr. Manti.
If remanded, the matter may be remanded.
You see, the challenge in the present petition, this is in 4728. The challenge in the present petition is to an order dated 29th April 1998, passed by the Additional District Magistrate. Bhubaneswar, in revision case number 424 of 1998, as well as an order dated 11th February 2001, passed in WL lease case number 2038 of 1973, whereby the lease in favor of the present petitioner has been cancelled. Full stop. It must be noticed here that while directing notice to issue in the present petition, notice was issued in the present petition on 26 September 2014, but till date no counter affidavit has been filed. Paragraph. On 10th October 2022, an additional affidavit has been filed on behalf of the petitioners, pointing out inter alia that the similar order passed in revision case number 426 of 1998 was revisited by the ADM by passing a subsequent order dated 26 July 2004, holding that Sri Hulasa Nayak was eligible to get the land on lease. Full stop. Paragraph. It is pointed out that as far as the present case is concerned, it arises from a similar order passed in
identical set of facts. Contiguous land, same date these was granted, same
identical set of facts, and accordingly, a similar order is required to be passed as far as the present petitioners, who are the successors in interest of Vilas Nayak, is concerned. Full stop. This is not disputed by counsel for the state. Full stop. In that view of the matter, the impugned order dated 29th April 1998 in revision case number 24 of 1998 and the order dated 11/2/2001 in WL lease case number 2038 of 1973 are hereby set aside. And revision case number 424 of 1998 is restored to the file of the ADM Bhubaneswar for being proceeded with afresh in accordance with law. Full stop. It will be listed before the ADM Bhubaneswar on 27th February 2023, on which date the petitioner will appear together with a certified copy of the downloaded copy of this order. The ADM will proceed with the matter afresh and pass a reasoned order, preferably within a period of 4 months thereafter. Till then, the status quo be maintained by the parties.
The rest of the matters have been rendered infructuous in view of this order which have been.
All right. Then the remaining matters, you say in view of the order passed today in WP Civil 4728 of 2014, the remaining writ petition 4727 of 2014 has been rendered infructuous and is disposed of as such. All right.
Okay.
May I be pleased to mention passover item 22?
The weekly list.
Of weekly list, my lords. My lords, on the last occasion has passed over this matter with a direction to provide the Honorable Apex Court order wherein this writ petition has been stayed. The present writ petition is placed under serial number 19.
By virtue of the order dated 14/12/2015 passed by the Supreme Court of India in SLP Civil number 15869 of 2015 and TP Civil 832-854 of 2015. Further proceedings in the present writ petition have been stayed. Full stop. The writ petition, this writ petition is accordingly adjourned sine die, with liberty to parties to mention it for listing after the decision of the Supreme Court in the aforementioned case.
Mature.
Weekly list. Item number 74.
None appears dismissed.
Item number 75.
None appears dismissed.
I'm sorry. Item number 77.
Item
number 77.
None appears dismissed. The interim order is vacated.
item number 78.
I may please mention. In the opposite case, the prayer of the petitioner is that the OP number 2 and 3, authorized officer and senior manager of the Federal Bank be directed to execute the deed of transfer in respect of the auction property and to deliver the physical possession of the auction property. Admittedly, since 2015, I have no instruction whether in the meantime it has been executed and registered or not. I have no instruction regarding that. He is a successful bidder. He has paid the full bid amount. In spite of that,
Just come to para 7 of the reply.
Yes.
Reply para 7.
Para 7. Yes. Bank, but bank has not executed a deed of transfer in respect of the mortgage property.
Property is not mutated in favor of the bank. How can the registration be permitted? Because there is a direct decision of the Honorable Court that record of right must be there in favor of the vendor, or you have to link, the link documents have to be produced.
Correct.
Yes, my lord. There is an amendment at Annexure 4. There is a circular that the transferor has to produce the record of right.
Correct.
Has the bank been served here?
But this is also seems to be ridiculous. How the bank will get the record of right? That because bank is giving sale certificate to the auction purchasers.
See, the original vendor has to
be there in the record of right.
Original
the borrower or the mortgager, whosoever may.
So the bank cannot do this, madam.
Bank cannot get the mutation ROR.
Served. All right.
Once the sale certificate has been issued, I paid the full amount before the bank. Then
the bank is not the seller of the property. In this case, the bank is simply auctioning the property. The property still belongs to the borrower.
I think recently the sale certificates are also registered.
Yes.
Now all the sale certificates are registered. This is the new. This is of 2014, na?
In that light.
All right. The present writ petition has been filed seeking directions to the opposite parties, Federal Bank, to come forward to execute a sale deed in favor of the petitioner, who happened to be the auction purchaser of the property in question, at an auction conducted by the bank. Paragraph. It has been explained in an affidavit filed by the District Sub-Registrar Bhubaneswar, bracket opposite party number 4, that the ROR in respect to the land in question was did not contain any entry in favor of the bank. Full stop. In other words, it is only the name of the original owner which continued in the ROR. Full stop. Without its name being entered in the ROR, it's not possible for the bank to have executed the sale deed. Full stop. Today, none is appearing for the bank despite service of notice. Full stop. If the ROR still is in the name of the original owner, that is the borrower, comma, it is only the borrower who can possibly execute the sale deed.
My lord, in that case, he will be put to problem because borrower will never come forward to execute the sale deed. It is always the bank he is to, because once the property is mortgaged and it is put to auction, bank is giving the sale certificate, bank has to give the registration has to be done by the bank, because this owner will never come forward because he is a defaulter. He will never give any cooperation to the auction purchaser.
What is the circular of 25th April 2014? There's a reference to that circular.
So that's what this DSR is saying, that because it is not recorded in the name of the bank, so it is not possible. That according to me, it is not a proper
registration of the sale certificate.
Registration of the sale certificate or registration of the sale deed at the instance of the bank. Because nowadays the banks are directly executing and registering sale deeds in favor of the auction purchasers.
Yeah.
Your Lordship may direct the bank to take the appropriate steps for transfer of title in favor of the auction purchaser, basing on the sale. Now the bank will take care of it. Because borrower giving a responsibility to the borrower not suffice her
states that at present, even sale certificates issued by the bank in favor of auction purchases are being registered. Full stop. In that view of the matter, a direction is issued to the Federal Bank, bracket opposite party number 2, to take steps to have the sale certificate as well as the sale deed in favor of the petitioner auction purchaser registered in accordance with law. Full stop. A copy of this order be sent to the opposite party number 2 for compliance.
Your Lordship may also give a direction that the DSR will also accept such registration. District
If the bank comes forward to have the sale deed registered, sale deed and sale certificate registered, then the sub-registrar Bhubaneswar, bracket opposite party number 4, will
allow the same,
permit the same, and proceed to issue the sale deed, register the sale deed in favor of the petitioner. The above exercise be completed within a period of 3 months from today. The petition is disposed of.
Item number 79.
Before I take your Lordship to the other matters here, there is a mistake appearing in the repetition. I have challenged, in fact, the 13.2, but typed out as 13.4. Therefore, I have prayed for correction, my lord. I have challenged, in fact, 13.2. But challenging 13.2 at the present moment, Mardia Chemicals and Umakanta Mahapatra's case.
Correct.
But
not permissible.
I'll not have a case before your Lordship to proceed your Lordship to cast that.
Correct.
So therefore, my lord, my alternate prayer for Lordship would be, I have applied for OTS. That's also my prayer in the repetition.
All right.
Later direction we given to consider that only.
All right. Mr. Rathak limits the prayer in the present petition to a direction to the bank to consider the petitioner's request for a one-time settlement in terms of the extant policy of the bank. Paragraph. In that view of the matter, a direction is issued to the bank to consider the petitioner's application for OTS if such application is made not later than 16th February 2023, in accordance with the extant policy of the bank, and communicate its decision to the petitioner within a period of 4 weeks thereafter.
But I have deposited 30 lakhs in terms of orders first.
Yeah. The bank will take into account the money's deposit by the petitioner thus far.
Grateful.
Petition is disposed of.
Item number 80.
None appears dismissed.
Item 81.
81, I am appearing through virtual mode, my lord. I may be permitted. The petitioner has already settled the loan with the bank, my lord.
All right. So it's infructuous. Counsel, the petitioner states that the loan amount has already been settled with the bank.
Lord, I am there for the opposite party bank. I am there on virtual mode. My appearance may be noted.
All right. The petition is accordingly disposed of as having become infructuous.
Item number 83.
None appears dismissed.
Item number 84.
Memo is taken on record. Dismisses in no instructions dismissed.
Item 85.
May I please?
My lord, I'm appearing for the opposite party.
All right. None appears to the petitioner. Dismiss the no-cause.
My lord, the short prayer.
Yes.
My lord, in the meantime, the opposite party number 2 has already expired.
Or
Dismissed. Dismissal.
Item number 86.
none appears dismissed.
Item number 87.
None appears dismissed.
Item number 91.
None appears dismissed. The interim order is vacated.
Item number 93.
93.
93, sir.
None appears dismissed.
Item number 94.
May I please your lordships? Matter relates to resumption of wasteland leased out to the petitioner under OGLS Act, my lords. Mr. Lordship may kindly have a glance at Annexure 1 at page 8, my lords. No opportunity of hearing has been afforded to the petitioner and the land has been resumed, my lords. And the second thing is, my lords, this has been done under section 3A of this OGLS Act. Resumption is land is supposed to be done under section 3B.
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 Might be some typographical mistake. 3A, 3B, but he has exercised the jurisdiction for resumption of the land.
My lords,
without notice to him, sir.
My lords, that is the fact.
Remand.
Yeah. You see, admittedly, the impugned order dated 30th August 2002 passed by the Tahsildar Bhubaneswar under section 3 capital A of the OGLS Act 1962 bracket Act, resuming the land leased out to the petitioner by order dated 12 June 1978 in WLL case number 186 of 1978 was without prior notice to the petitioner. Paragraph in the present petition, despite notice having been issued. No, but never listed. There's no interim order also. Then what happens? You're still in possession.
My lords, position. I'm in position, my lords.
That view of the matter, the impugned order dated 30th August 2002 is hereby set aside and the matter is remanded to the Tahsildar Bhubaneswar and the matter that is WLL number 186 of 1978. No, that is 1692 of 2000. What is that?
Pardon, my lords?
No. What's the case before the Tahsildar?
Tahsildar.
Yes. Tahsildar, my lord, WLL 186 of 1978 and RC number 31 of 90.
The case before the Tahsildar will go by what number? Because that WLL is already over. You got your lease under that.
Your lordship may kindly have a glance at page 8, my lords. The WLL.
It's a type of case.
My lords. And beside that, it is written RC number 31 of 94.
Oh, that is the court of ADM, Bhubaneswar. How you are saying that it is Tahsildar? 31 of 94.
That's before the ADM, is it?
No, that is the reference in the order of the Tahsildar.
This is Tahsildar Bagatipur.
My lords. Annexure 1 is by Tahsildar.
But what's the case number? There are so many numbers. One an RC number is given.
RC number, your lordship may kindly have at page 10, Annexure 2. The Tahsildar first referred the matter to the ADM to decide it under section 7A 3, my lords. But the ADM said that since 14 years has elapsed, so he cannot take a decision. And he dropped the proceeding. Again, Tahsildar has passed this order.
Where is that order? Where is that?
Annexure 2, page 10, my lords.
No. Annexure 2 is the ADM's order. I think this order is in your favor.
Yes, my lords.
ADM has dropped the proceeding.
But then after which the Tahsildar
that afterward order is not annexed. That is what.
No, that is at Annexure 1.
Annexure 1.
Annexure 1.
Okay. WLL 186 of 1978 is restored to the file of the Tahsildar, where it will be listed on 27th February 2023. For being proceeded with afresh, petitioner will appear on that date before the Tahsildar with a downloaded copy of this order. The Tahsildar is thereafter directed to dispose of the matter in accordance with law after hearing the petitioner with a reasoned order. within a period of 4 months thereafter. Till such time, the status quo shall be maintained.
Item number 95.
My lord, I am here for item number 91.
Hey, 95.
95, sir.
Wait.
I'm from the opposite party, my lord.
Okay, one appeals for the petitioner. Dismissal or opposition.
Item 98.
May I permitted to mention, my lord, item 85, my lord.
You'll have to wait, sir.
98, my lord.
Item 98.
98, may I please, your lordship. My lord,
Yes.
the petitioners being the street vendors approached before this honorable court challenging the illegal action of the Bhubaneswar Municipal Corporation. Those who are going to, my lord, evict the petitioner by loudspeaker announcement without my lord, affording any, my lord, opportunity of hearing and show cause, my lord. And the petitioners are, my lord, the BMC allotted the, my lord, vending zone to the petitioners. My lord, that is at page 14, annexure 1.
Who's for the BMC? I am appearing, my lord. Through VC. But this is of the year 2014, and there is no such allegation. Already the BMC has carried out the survey as per the instruction, and out of all the petitioners, only some of the petitioners have been enlisted in the street vending empanelment as per the Street Vending Act, my lords. And in that area itself, the Odisha Water Supply and Sewerage Sanitation Board has been established, and to carry out the passage to that road. So these people are no longer these people are no longer there.
We don't have any. They are not the street vendors as per the survey carried out by the BMC.
When was the survey carried out? When was it carried out?
My lord, that has been carried out in the meanwhile, my lord, after 2014, and only serial number 1, 3, 6, 9, 18, 26, and 28 under Annexure 1. These they have been found to be entitled to get. Other petitioners are not. And my lord, also there
where is your affidavit, sir?
That could not be filed if Malas may grant sometime.
Counsel for the BMC assures the court that an affidavit will be filed. On or before 27th February 2023. List in the regular list, the supplementary list on 6th March.
Interim order to be continued, lords.
Where, sir? I don't know where people are there or not. He says there are no shops. There is some other building now.
My lord, if the registered body, my lord.
Let's see what happens. It's okay. Let's not continue then tomorrow. Because he says the ground situation has changed.
My lord, paper has been filed, my lord, by the municipality.
Anyway.
Item number 102.
Well, on 102, the matter has become infectious, man.
All right. Dismissed as infectious.
103.
None appears dismissed.
Item number 109.
None appears dismissed.
I'm for the petitioner.
109.
Yes. This case, lordship, the OP4 meantime died, lordship, I may be permitted to take step for substitution, lordship. I have collected the details of its legal heirs.
Now, sir, after 2014?
No, it's on 20th, after a fresh issue notice, lordship by the order dated
109. 109.
15th, 12/21, lordship, director for fresh notice. I've issued notice, and thereafter I came to know that on 30th 7/2020, he has died, lordship. I have already collected the details of the legal heirs. I'll take the step to.
Legal heirs of?
OP number 4. OP4, lordship.
Counsel, the petitioner states that he'll have to take steps for bringing on record the LRs of OP number 4. That's only a pro forma party.
My lord.
At his request listed the supplementary list on 10th May.
Item 110.
Interim order continue.
What interim order?
So interim order there also 1009.
What interim order?
The status quo be maintained by both the party jealous.
Then that's okay. That continues.
Oblige.
Interim order to continue. Okay.
Item 110.
Sandeep Dhawan.
None appears.
Sandeep Dhawan.
Yes. Interim order, I don't know if there's an interim order. No. Interim order is located.
Both the cases.
Yeah.
Item number 112.
May I, my lord, I may be permitted to place this matter on behalf of Mr. Patnaik. But in 74, the lease was granted in favor of one Gopal Maharathi, and he applied for sale of the land to the revenue officer, and revenue officer granted him permission to alienate the same. Accordingly, the grandfather of the petitioner, present petitioner, purchased the same, the leasehold land of the Gopal Maharathi in the year 1980. Now, my lord, 25 years after the...
No notice was issued to you.
Hello?
Notice was not issued to you in the...
it is beyond 14 years. The law was then...
No, you are the bona fide purchaser or the original lessee?
No, I'm the bona fide purchaser.
No notice was issued.
And then 14 years, my lord.
That point you have to raise with
14 years, my lord, that is directly covered by our own High Court, sir.
Point that out to the ADM.
You have to point out before the
Again, my lord, this
the petitioners are the bona fide purchasers from the original lessees, against whom the impugned order dated 30th June 1998 was passed by the AD movement in leave case number 614 of 1998. So the petitioners admittedly purchased the property by a registered sale deed on 17 September 1980 itself. Consequently, the impugned order could not have been passed without impleading the present petitioners as parties. Paragraph on the above short ground, the impugned order is set aside. Lease revision case number 614 of 1998 is restored to the file of the ADM Bhubaneswar, where it will be listed on 1st March 2023, on which date the petitioner will appear, together with the downloaded copy of this order. The ADM is requested to thereafter proceed in accordance with law and dispose of the case within a period of 4 months thereafter. Till such time, the status quo as of today shall be maintained.
The question of limitations, Lordship has not dealt with, and it has to be dealt.
That's all the pleas. It will be open to the petitioner to urge all pleas available to them in accordance with law before the ADA. Right.
Item 113.
Obliged.
None appeals dismissed.
114.
Same order.
115.
Same order.
Item 116.
None appears dismissed. The interim orders. Even the earlier matters. All interim orders are clear.
Item 117.
None appears dismissed. The interim orders are clear.
118.
And in this case, the petitioner challenged the order of commission endowment under Annexure 8 minor under Section 19 of Odisha Hindu Religious Endowment Act on the ground that the commissioner, while deciding the dispute, he has not considered the decision reported in AR 1981 Supreme Court 798, where the Honorable Court decided the principle regarding the deity, whether belongs to public or private, my lord. In this case also, my lord, has the commissioner also not considered the report of the endowment inspector, my lord, which stated that the deity is a private deity, my lord. In his inquiry report, my lord, page 36, my lord. Annexure Annexure 7, page 36, my lord. At present, Sri Bhagavad Dev is being worshipped in shape of Pothi along with Ma Mangala Thakurani inside thatched house of just adjacent to residence house of Guru Charan. 1908. This honorable court also in a case WPC note 27244 in a 19A case directed to approach fresh mail.
That was in my case, your lordship directed to approach afresh. That was in my case. Because it was in way back, in the long back, therefore he can approach again. That in my case, that was short order. He can approach afresh.
But if it is not an endowment property, why did you approach?
19A. Private, no objection.
Okay, since the situation, just say this, since the fact situation in the last 8 years since the impugn order was passed has changed, the court permits the petitioner to apply afresh for permission to sell the properties of the deity by submitting an appropriate application to the Commissioner of Endowments. Full stop. If such application is filed not later than 1st March 2023, be considered on its merits in accordance with law by the Commissioner, and a fresh order will be passed thereon within a period of 2 months, without in any event being influenced by the earlier order dated 19 September 2014 of the Commissioner. The petition is disposed of the workers.
Item 119.
None appears dismissed.
Item number 120.
Same order.
120.
In 19, 20, and 21. Item 121.
Same order. Same order is vacated. Orders.
Item number 123.
None appears dismissed. Interim order vacated.
Item number 124.
Please, my lord.
The interim order was there, my lord, till 31/1/2015. Thereafter, it has not been
extended.
Sorry. We have filed an extension application for extension. However, my lord, I am placing on the facts, my lord.
Yes.
The petitioner's prayer was for setting aside the Annexure 5 series, which is the notices of eviction sent by the NSE. And secondly, that we may be declared that we have the right under section 5, Rule 5B of the OGLS rules, that the lands may be settled in our favor. Now, the background is that the land admittedly is in nature of Parambok land, which can be settled after 2010. Rules have come under OGLS Act that this can be settled in favor of the persons who are staying over there for a certain period of time, requiring, and they be having a certain amount of income. Now, my lord, that we are eligible for that kind of all the eligibility conditions we have settled, my lord. In the meantime, the NSE, who has no authority over the land, has sent us the eviction letter, that eviction notice that you have to vacate the land because this land belongs to NSE. They have not filed any counter affidavit to that extent that the land belongs to them. In fact, the state has filed the counter affidavit. It states that the land belongs to, in fact, the state government, not the NSE. Therefore, my lord.
Mr. Mohanty, whom are you appearing for?
For NSE, my lord. My lord, your lordship may kindly look, they were paying rent to the NSE. And this was used, this place was used as a child tree or a rest house. My lord, child trees, your lordship would not be knowing that is the synonymous for a rest house.
Right.
And after the rest house became dilapidated, they were sitting there and selling vegetables. And they were paying rent to the NSE, that is phase 15 onwards, they have annexed the rent. Okay. Thereafter, NSE, in order to has issued this notice for eviction, because it became dilapidated. It is in Odia, that notice.
Yes.
Someone can read it without. এই ঘরে তুমি রହୁଥିବା গৃহ নম্বর 4টি বহু পুরাতন অଟେ ଏହା ବିପଦ ସଂକୁଳ ବୋଲି ପୂର୍ବରୁ ଘୋଷିତ ହୋଇସାରିଛି. That it is dilapidated and dangerous. So in order to demolish that, the notice was issued. And all lands within the area of the municipality of the state government, the municipality is to look after me.
What is your claim? Why should you be allowed to continue?
My lord, the first is that the land doesn't belong to the municipality. That is clear from the counter affidavit filed by the state. The paragraph number is para 7 of the counter affidavit. The second paragraph of the para 7. It says, may I read for the honorable court, my lord?
No, but are you continuing?
Yes, my lord. We are continuing. And my lord, also page 13 is the settlement report, where the nature of the land has been mentioned. It is land is Parombok. It is written in Odia. Now the amendment came in the year 2010. May I read the amendment? Odisha Government Land Settlement Rules 1983.
But the question is whether that house where they are selling is dangerous and dilapidated. That is why the municipality has issued the notice. It is not regarding the question of title.
Yes, that is the fact. Once the building is found to be dilapidated, it is the on NSE to issue the eviction and demolition notice, not the Tahsildar. So, because it is within the NSE area. So, there is no infirmity in it.
As because we are all having our income, we are barely meeting our income through
that you can say,
but at the cost of your life.
My lord,
at the cost of your life.
My lord, our contention is that there is no threat to our life. In fact, this
you are not the best person to say that.
It's to be declared unsafe and it has to be demolished or restructured.
If it is to be,
if something happens,
my lord,
who will be held responsible?
My lord, my submission with that, if they are the best authorities to decide whether the buildings are dilapidated or not.
Are you the best authority?
No, my lord. My lord, at least
which is the better authority?
At least our roof may be protected.
Which is the better authority to decide?
The state government, my lord. At least our roof, at least we must be ensured a proper roof so that we can stay.
If you're dilapidated, where is proper roof, sir?
My lord,
the place is dilapidated.
The nature of the land was that it was the history behind these particular lands are that earlier the king who was there, he built these houses for resting the people who come to pilgrimage or for any other hospital purposes, and these persons have been staying for whatever reason for 30 or 40 years. In the meantime, it is admittedly these lands, the buildings were not properly taken care of. And that was also in fact that if they say that this is dilapidated, that then in that case also, my lord, it is also the duty of the municipality to ensure that the buildings don't get dilapidated.
They were the leaseholder, they were licensees, they were paying rent to the municipality.
My lord, if I am a license, I'm sorry, I interrupted Lanil Singh, my lord. If I am a licensee, then a proper procedure is to be followed to evict me. And in the meantime, my lord, the law has changed. in the 2010, I'm reading the law, my lord. The law has seen what does it say? It says that notwithstanding anything contained in Rule 3, 5, 5A, 8, 11, 12, 13, settlement of Khas Mahals, Nazul land, leased out, and Gramakantha Parumbok. This is the particular nature of land. And Avadi land occupied prior to 26 February 2006. This is the, my lord, date. And used for homestead purpose shall be settled in the manner prescribed in Schedule 5. Now, my lord, Schedule 5 is the procedure there is there. And in the meantime, also, we have filed application under the relevant rule for settlement of the land. If it is settled in our favor, then, my lord, the dilapidated structure, we can take best care of it. What I am saying is that my right over the property can be taken care of by the state, and in the meantime, I may not be evicted, because once I get evicted, this right I cannot exercise in the meantime, my lord. I have also filed an application for settlement of the land. Let the state government decide over my right over property as per this Rule 5B, my lord.
My lord, my respectful suggestion is that the application for settlement which he has filed, that will be considered in accordance with law. But so far as demolition is concerned, your lordship may not give any restrictive order, because the NSE has decided on the ground that it is a dilapidated construction. Let it be demolished, and your application for lease under that amended rule will be taken care of, notwithstanding the fact that there is no existing structure over the land in question.
Existing structure of the land as recorded is used as a rest house.
That the Tahsildar will take care of in accordance with law. He will take.
Right. We have no objection.
All right. The prayer in the present petition is that the opposite party should be directed to settle the land presently said to be under occupation of the petitioners in their favor under the Orissa Government Land Settlement Act.
That amended rules.
Yes, that is Rule 5B of the OGLS Rule 1983.
And Rule 5 capital B of the OGLS Rules 1983. Paragraph. It appears that petitioners are occupying chaul trees given on license basis to them located at Bhanjanagar, Ganjam, which have since become dilapidated. The chaul tree stands transferred to the Bhanjanagar NAC, opposite party number 3. Full stop. The license in favor of petitioners have not been renewed. Even though they continue to stay in the same chaul trees for over 40 years now. Full stop. The plot over which the chaul trees are located are recorded as single quotes Gramakantha Parumbok, unquote. The fact of the matter is that the premises occupied by the petitioners are in fact very old and dilapidated, and it is unsafe to permit them to occupy the said premises. Full stop. The question, therefore, of continuing any interim order in their favor, protecting their position, cannot arise. Full stop. As far as the prayer under Schedule 5, bracket Rule 5, capital B of the OGLS Rules 1983 is concerned, it will be open to the petitioners to approach the Tahsildar.
Oh, yes, ma'am.
Tahsildar, yes.
He is claiming that he has already filed, but there is no record to that effect.
I filed in my rejoinder.
Filing an appropriate representation.
Not representation, my lord. They have to file appropriate.
Yes, proper application is there.
Application under the format is there.
In the appropriate application. We'll stop. If it is filed not later than 1st March 2023, it shall be examined by the
There is a long procedure. Tahsildar will send it to sub-collector. So it is ultimately the government will grant the lease. Anyway, but with a time frame may be granted within that period, all the exercise.
The ultimate decision thereon will be communicated to the petitioner within a period of 4 months thereafter. No further directions are called for in the present petition. The interim order is vacated. The petition is disposed of.
We are grateful.
Item number 125.
My lord, in this case, the petitioners are landless persons. They occupied the subject government property, which the government wanted to acquire for their purpose. So the petitioners, they applied either to settle the land under their occupation or in alternative to allot any land in their favor, being landless persons. And to that effect, the Tahsildar, who made the spot inquiry by para page 16, I am reading, the Tahsildar has reported that the...
So what provision are you asking for settlement of the land?
Being landless persons.
No, what provision?
Under the OGLS Act.
What provision, sir?
Section 7.
7.
The landless persons are to be...
Section 7 of the OGLS Act is appeal.
3 and
OGLS Act, Section 7.
3 and 7, it provides to earmark land for the landless persons to allot. Settlement of land for homestead purpose in rural areas. Admittedly, these are the landless persons. And also the Tahsildar has recommended.
OGLS 7 ta hala ba appeal.
Odisha Government Land Settlement. Section 7.
Section 7. And appeals shall lie against any order.
I know what Section 7 is not applicable at all. Section 3 must be.
3 is there. That is what I'm saying.
But it's Section 3, subsection 3 gives the priority. Under what category are you falling? Under 3.3.
Any landless agricultural laborers of the village in which the land...
I don't think he's an agricultural landless laborer. Are you a laborer? Agricultural laborer?
Landless laborers.
No, laborer. There is no averment to that.
Agricultural laborer, sir. Are you an agricultural laborer?
Chassis.
My lord, may I read out the recommendations of the Tahsildar at page 16?
Other than agriculture, he has to be in agriculture.
He has recommended to rehabilitate at page 16. I am reading only 2 lines. Tahsildar has reported that the encroachers would be rehabilitated in any other place as per norms of government before handing over possession of land to IDCO. So they repented to the government. My only innocuous prayer that our application on Annex 2 and 4 is to be considered to allot us land by the authority.
That can let them represent the collector, but so far as this particular land is
land, we have
there is a status order. There is a status that has to be vacated. Because
it is already taken over by IDCO. These persons they could not maintain.
Or it appears that during the pendency of the present petition, possession of the land has already been taken over by IDCO,
by the government.
Possession of the land has already been taken over and handed over to IDCO.
Yes.
Full stop. That be the matter while vacating the interim order. It is directed that if the petitioners make an appropriate application to the government for settlement of land in their favor, it will be considered in accordance with law by the government.
Collector kariyo. My lord, collector of the concerned district government it is
by the competent authority.
Yes,
specific direction.
The petition is disposed of there.
Item 126.
May I please your lordship? My lord, the petitioner's EMD amount has been forfeited by the bank. The petitioner participated in the auction of a property and deposited EMD. but later came to know that the bank has not yet taken physical possession of the property. So the petitioner the petitioner became successful bidder, but did not make deposit of rest amount and made application for refund of his EMD amount.
No, but what is the condition? Is it to be forfeited? Auction condition is what?
For bank published e-auction notice for secured for sale of secured assets.
That's right. If you're unable to pay up the auction amount, you'll actually forfeit whatever EMD you've deposited.
My lord, the bank has not disclosed that the property bank has not taken possession of that property till the publication of the notice. Bank, without taking possession, published notice for e-auction of the secured assets.
It can, but you did not pay the amount, sir. You were the successful purchaser or what?
I became successful bidder, but I could not. For that purpose, I did not make deposit.
Actually, then you forfeit the EMDs. Yeah, it's a condition of the auction itself, sir.
My lord, they have when they publish the notice, till that date, they have the bank has not taken physical possession of the property.
That was not necessary. Anyway, you participate with open eyes, sir. The bank never gave you any assurance that they are taken possession.
My lord, the Surface Act provides after taking physical possession, property can be sold. And I'm giving it two judgments of Karnataka.
No, but it's not mandatory, sir.
That is not the
Yeah. Correct.
police assistance.
Statutory provisions do not authorize the bank to sell the property. Which statutory provision?
My lord, Surface Act, Section 13 and 14.
Let's
the
read that.
Securitization Act.
Let's read that. Which provision, sir?
My lord, borrowing including right of transfer of lease. My lord, 4A. 13 4A. In case the borrower fails to discharge the liability in full within the period specified in subsection 2, the secured creditor may take recourse to one or more of the following measures to recover his secured debt, namely, take possession of the secured assets of the borrower.
May take recourse, sir.
My lord.
It doesn't say he has to.
Symbolic possession is also
Possession.
a possession.
My lord, they have not.
There is no requirement. It doesn't say that no sale of the property can take place unless possession is taken. Where is such a provision?
Otherwise, there would not have been a provision like Section 14 for police assistance.
My lord.
After sale, that contingency arises. Section 14 will not.
My lord, that
that we don't know. The prayer in the present petition is for a direction to the opposite party bank to return to the petitioner the earnest money deposit of rupees 13,10,000, which was made by the petitioner at the time of participating in the e-auction conducted by the bank. Paragraph. Admittedly, the petitioner who became the successful bidder failed to make payment of the required amount, and which resulted in forfeiture of the EMD by the bank. paragraph, it was sought to be argued that without actually taking physical possession of the property in question, the bank could not have resorted to putting it up for sale through e-auction. In support of such contention, reliance is placed on the judgment of the single judge of the Karnataka High Court, dated 1st June 2015, in repetition number 15546 of 2011, bracket E. Ali versus Syndicate Bank, bracket. Although in the said case, it is observed that there is a statutory requirement of the bank having to take possession of the property before putting it up for sale through public auction. There is no reference made to the actual provision, statutory provision. Counsel to the petitioner drew attention to section 13, bracket 4, bracket A of the SARFAESI Act, which states that the secured creditor may take recourse inter alia to including taking possession of the secured assets. For realizing the secured asset by sale. The said provision does not make it mandatory for the bank to take possession of a property before putting it up for sale through auction. Further, the expression single quotes take possession unquote does not imply necessarily taking physical possession. It could even be constructive possession. Paragraph. Consequently, the court is unable to agree with the submission that there was justification for the petitioner to have not paid up the bid amount, despite being the successful bidder. Feature of the EMD as a result of the failure of the petitioner to pay the bid amount was consequential and cannot be said to be arbitrary or illegal. Consequently, the court declines to grant the relief prayed for. The petition is dismissed.
Item 127.
I am for OP number 1, my lord.
None appeals for the petitioner. Dismissed on non-consequential. Interim order is vacated. Both matters.
128.
May I please, Lord? This is arising out of a dereservation proceeding under the Odisha Government Land Settlement Act. Section 3A of Odisha Government Land Settlement Act provides if there is a dereservation proceeding, then the collector of the district shall initiate the proceeding, and if he will receive certain objection from the villagers, then the matter will be referred to the Tahsildar, concerned Tahsildar. The Tahsildar will record the regions, and he, after recording the regions, submitted the same to the collector, and the collector, after hearing the villagers, shall take a final decision. Under Annexure 3, in way back in 2010, the Tahsildar initiated a proceeding, not the collector. The villagers challenged the same before this Honorable Court, and the collector accepted the same and de-reserved this entire government land, for which the villagers approached this Honorable Court by filing a writ application. This Honorable Court found the proper procedure has not been followed. Therefore, the order passed by the collector was set aside, and the collector was directed to follow the Odisha Government Land Settlement Act and the rules, and thereafter pass order. Notwithstanding that judgment, the collector repeated the same thing. Then another writ application was filed by the petitioners before this Honorable Court. This Honorable Court has also quashed the same and directed the collector to follow the OGLS rules and pass necessary orders. Despite that, Annexure 3 is the first order passed by the collector, which has been quashed. Annexure 7 is the second order passed by this Honorable, passed by the collector, quashed by this Honorable Court in another writ application. The same thing has been repeated by the collector under Annexure 8. I will take your lordship to First of all, I will take your lordship to section 3 capital A of the OGLS Act.
Yes.
Power to de-reserve the land. This government may, by notification in official gazette, authorize any officer not below the rank of the collector to de-reserve any land which has been reserved under clause A of section 3 of any government land recorded as gochar or any portion thereof. Therefore, the collector is the competent authority to initiate a proceeding. The government has also been notified in a notification which is attached to the just after the act. There is a notification of the government of Odisha on 29th of January 1974, where it has authorized in exercise of the power conferred by subsection 3A of Odisha Government Land Settlement Act, the state government do hereby authorize all the collector of the state to de-reserve any land which has been reserved under clause A of section 3 or any portion thereof within the district under their respective jurisdiction. Then I will take your lordship to rule 4, how the de-reservation principle shall be followed. OGLS Rule 1983, I am placing Rule 4. Any land which has been reserved under clause A of subsection 1 of section 3 or recorded as gochar may be de-reserved by any officer not below the rank of the collector authorized by the state government in that behalf. In making such de-reservation, the following procedure shall be followed, namely, a notice inviting objection to the proposal for de-reservation specifying particulars of the area to be de-reserved and its situation such as village, gram panchayat and town, khata or holding and plot number and extent shall be published in the manner prescribed under sub-rule 6 of Rule 5. A period of 30 days shall be allowed for filing of the objection, if any, before the concerned Tahsildar. Lordship, this is the crux. If during the said period no objection is received, the Tahsildar shall submit his proposal for a de-reservation, giving justification for the same. In case the objection filed before the Tahsildar, he shall hear the parties on the date fixed by him, and after such hearing, shall forward his recommendation to the authorized officer for orders. In respect of the recommendation from the Tahsildar, the authorized officer may, on being satisfied with the ground advanced by the Tahsildar for de-reservation, accept and modify the extent if he is considered necessary or reject the same. This is the requirement of law. Here, the collector initiated the proceeding, objection was filed, objection was never forwarded to the Tahsildar and passed himself the order, despite the fact that I have quoted the previous order passed by this honorable court. First order I have quoted at paragraph 12, page 12, order dated 1/11/2012. There the impugned order at page 13. Therefore, the impugned order is liable to be quashed and accordingly quashed, because the collector had not followed the procedure.
No, in the last round, why is he not? What has he done again wrong? This
Again
Annexure
wrong.
8, you're now challenging Annexure 8.
Annexure 8.
What is wrong with that?
Yes, I am pointing out. Your Lordship, page 57. Clause IV. That is the operative portion of the order. As regards under Rule 4.1 of the OGLS rule, the Tahsildar had invited objection to the proposed de-reservation, but no objection was received within the stipulated period of 30 days. Accordingly, the Tahsildar submitted proposal for de-reservation to the collector through the sub-collector. After lapse of more than 1 year, passing of the de-reservation order by the collector, the present petitioner filed the case before the Honorable High Court. The Honorable High Court, by their order dated 1/11/12 in WPC number so and so, while passing the order of the collector on the ground that the collector had not applied his mind and accepted the recommendation of the sub-collector, remitted the matter back to the collector to rehear the matter, and after giving opportunity of hearing to the petitioner and other interested persons, if any, may pass appropriate order in accordance with law. In compliance to the said order, the Honorable High Court, the collector has heard the petitioner to dispose of the matter in accordance with law. At this stage, there is no scope to remit back the matter to the Tahsildar. The statutory requirement is that the matter has to be remitted to the Tahsildar for consideration. The Tahsildar is competent to hear the objection and take the oral evidence. How can that power be exercised by the collector? That is the rule 4.1. That is due to this violation, twice this Honorable Court has quashed the order and remitted the matter to the collector. The proceeding has to be initiated. My lord, the law is very clear. The proceeding has to be initiated by the collector. This land of the government requires this land to be de-reserved for this purpose. And if any objection is received, then objection before the Tahsildar. Before the Tahsildar, the villagers, there may be any number. They will come and they will depose before the Tahsildar. This is grazing land. This is necessary for our villages. This land may not be de-reserved. And the Tahsildar will record a reason and submit it to the collector. The collector may accept it, may not accept it. But the procedure of law is that. How can you deviate from these provisions? And particularly since twice this Honorable Court has set aside the order passed by the collector, the same thing will be repeated again. And there will be no rule of law.
Yes, my lord. Lordship may kindly see there is no infirmity in the collector's order in as much as the Honorable High Court has remanded the matter for the sole purpose to hear the petitioners. Now, my learned friend is saying that the hearing part should have been observed by the Tahsildar, not by the collector. But the Honorable High Court has directed that the collector should exercise its judicial mind and pass necessary orders. And accordingly, the remand order was passed. That is why the collector has heard the petitioners. The only question is the petitioners are to be heard. Their grievance should be put forth before the revenue authorities. Collector is the highest approving authority. And one thing your lordship should take into consideration, during the objection period, none of the petitioners filed any objection within 30 days. So later they approached the Honorable High Court, and by virtue of the order of the court, they were afforded opportunity of hearing. And the Honorable Court has directed the collector to dispose of the matter and take and consider the grievance of the petitioner. So I think there is no wrong committed by the collector. And apart from that, if your lordship will see the merit of the case, the collector has observed in the impugned order that there is surplus gochar land. It will not affect all the requirements under the law are fulfilled, and it is for a public purpose. The Central Warehousing Corporation, there is go down there for preservation of these articles, agricultural products, and it is already constructed, and the one council is also appearing for this Central Warehousing Corporation. So only ground he is now placing that this objection should have been dealt with by the Tahsildar, and collector should have again remanded the matter to the Tahsildar to consider those objections. But my respectful submission is that since the Honorable High Court has directed the collector to re-examine the matter and to exercise its judicial mind, that is why collector has taken care of the objections and dealt with the objection and disposed of the objections in accordance with law.
All right. The controversy in the present petition concerns the dereservation of land in village Masakani under the Mohakalpara Tehsil in Kendrapada district. Under Rule 5(2) of the OGLS Rules 1983. Bracket rules. Paragraph. The dereservation was occasioned by the request made by the Regional Manager, Central Warehousing Corporation, bracket CWC, for construction of 1,000 metric ton godown for storage of PDS material. Paragraph. Dereservation case number 9 of 2010 was initiated by the Tahsildar Marsagai. Since the land applied for was recorded as Gochar in the Kisam, it was noticed that there was excess Gochar land in that village. Full stop. A public notice was issued on 9th December 2010. Full stop. During the period of 30 days thereafter, no objection was received. Full stop. Tahsildar then proceeded to make a proposal to the collector, Kendrapada, through the sub-collector. Full stop. The collector, after examining the proposal, de-reserved the land in question under Section 3, capital A, bracket small c of the OGLS Act 1962. Full stop. Paragraph. Agreed by the above order, the petitioners first approached this court with writ petition civil 10688 of 2012. Full stop. The collector's order dated 24 January 2011 was quashed by this court by an order dated 1st November 2012 on the ground that the procedure had not been followed. Full stop. This court remitted the matter to the collector to rehear the petitioners and other interested persons and pass appropriate orders. Paragraph. In the second round, the collector again passed an order dated 22nd January 2013, de-reserving the land in question. This was again challenged in writ petition civil 14120 of 2013. Stop. The High Court again set aside the order of the collector by an order dated 27th August 2013. After observing that the early directions issued by the High Court had not been followed. Paragraph. For the third time, the collector heard the parties and
I beg pardon.
Again recommended and again de-reserved the land in question by the order dated 5th November 2014. Full stop. This has now again been challenged in the present writ petition, in which notice was issued by this court and the records were asked to be produced. Paragraph. This court has heard the submissions of Mr. Samal, Upendra Samal, learned counsel appearing for the petitioner, and Mr. D.K. Manthi, learned additional government advocate. Stop. Mr. Samal argued that the procedure to be adopted by the collector was to be found in Rule 4 of the OGLS rules, 1983, which envisaged the collector having to send the objections to the Tahsildar for hearing the parties, and then for the Tahsildar to forward his recommendation to the collector for orders through the sub-collector. Full stop. He submits that inasmuch as this procedure was not followed, the impugned order of the collector de-reserving the land in question has to be set aside. Paragraph. Mr. D.K. Manthi, learned AG, on the other hand, submitted that the hearing before the collector took place as a result of the order passed by this court, which specifically remitted the matter to the collector and required him to consider their objections. Stop. Since the order of this court had to be followed both in letter and spirit, The collector then proceeded to hear the objections and pass the impugned order. Paragraph, the above submissions have been considered. Full stop. While it is true that Rule 4, bracket 1, bracket Roman small 2 of the OGLS Rules 1983 envisage hearing of the objections by the Tahsildar. In the present case, the remand order of this court was specific that it is the collector who should hear the objections. At that stage, the present petitioners did not raise any objection before the court that it is not the collector who has to hear the parties' objections, but that it has to be done by the Tahsildar. We'll stop having accepted the order of this court and having participated in the proceedings with the collector. The petitioners cannot now be heard to say that the procedure adopted was not in consonance with the OGLS Act and the OGC rules. Paragraph. Consequently, the court is unable to find any error having been committed by the collector in proceeding with the hearing of the objections of the petitioners and deciding them in accordance with law. Paragraph. The court is unable to find, even on merits, any justification for interfering with the impugned order of the collector. Stop. The writ petition is accordingly dismissed and orders to cause.
My lord, item 85, my lord. Item 85.
142, 143, memo taken on record, dismisses not pressed.
Item 85, my lord, dismissed. Item 85. I was absent at the time of call of the case.
Tell us what it is. Come. Tell us. Tell us.
Tomorrow, my lord.
No. Then you'll have to file an application for setting aside.
Pattern number 2A expired in the meantime. I have to file a substitution petition.
Then you file a thing for setting aside.
Or recall that order.
Opposite pattern of 2 expired in the meantime.
It's all right, sir.
I have a small prayer, man. Tomorrow, in fact, I am out of Cuttack. One matter is remaining. Can it be passed over for the day only? Let it remain on board. I'll do it day after tomorrow.
Day after tomorrow.
Maybe 141 is identical to 180. That matter is your lordship directed to fresh consideration. 118. That matter to approach afresh. I have given it now identical order.
141.
141. Same with 118.
118.
118. Your lordship directed to approach afresh.
To the item 91. Can I see for
adjournment? I have given that order copy.
All right.
141.
All right. Right.